Good morning. I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We are going to continue our gavel-to-gavel coverage of the Richland County corrections officer who is facing very serious charges, manslaughter and reckless homicide, for the death of Alex Rios. This occurred at the jail back in September of 2019. The video, very tough to watch. I want to warn you, it's as Rios is being pinned to the ground. You're going to see an officer's not just one foot, he's got his foot on his back. You're going to see right here his second foot come off the ground, meaning he's got his entire weight on the back of Alex Rios. Rios would end up being put in the hospital because of this incident and end up dying 7 days later. There is conflicting testimony that has been given about the exact cause of death. The coroner who handled the original autopsy called it excited delirium. That's an individual that's on any kind of drug, methamphetamine, which there was in the system of Rios, that gets an excited state and it ends up causing the death. But on Friday, there was contradictory testimony from an expert coroner that was brought in that said there's no way that it was excited delirium. And in fact, the cause of death was homicide because of the weight that was being put on Rios's back. Let's take you into court this morning as we get our testimony underway.
Would it be fair to say that if you have your position and your title with BCI, you are essentially like a detective?
Yes.
Oh. And you work out of which office?
The Richfield, Summit County office.
And approximately at any given time, how many similarly positioned special agents are there out of Richfield?
Oh, it fluctuates. We've had as little as 6 and as many as 12.
Now, with respect to this case, you received a call from a gentleman by the name of, is it Mark Colmer?
Kohler.
Colmer. Who is he?
At the time, he was the special agent supervisor.
Kind of like your boss at the time?
Yes.
Okay. And he got in touch with you to make you aware that you were being assigned to the investigation of this particular case?
Yes.
And all of this is documented in an investigative activity note that talks about the investigative request, the preface, and it just kind of gives us some background circumstances as to how you were going to conduct this investigation. Have you reviewed that summary?
Yes.
Okay. And with respect to almost like the mission statement or the purpose of your investigation, what you outlined, or as your directive, the investigation, as written in your summary, was conducted with the purpose of determining, to the extent possible, the facts and circumstances surrounding this incident.
Yeah.
And that's all the facts and circumstances, right?
Yes.
Because they're all relevant to the investigation, yes? And those would be the facts and circumstances surrounding the incident related to all of the goings-on at the jail involving Mr. Rios, yes?
Yes.
From the time he got there until the time he was transported by medics to the hospital, yes?
Yes.
And also, whatever you could learn about Mr. Rios himself, right?
Yes.
And that including but not limited to anything you could learn about Mr. Rios in the weeks and time leading up to his arrest on the Richland County warrant that led to his transfer to the Richland County Jail, correct?
Yes and no.
Please.
So, what led Mr. Rios in the care and custody of the Sheriff's Department, and then from his time that he left to the hospital? But in a sense, as much as we can, yes.
Right, and that's why you not only sought out to investigate what happened at his time spent at the jail, but also you sought out the chief of police, I think, with the Wakeman Police Department to get a better understanding of the circumstances surrounding Mr. Rios' arrest and also the events leading up to that up there in Wakeman,
yes.
Correct? Okay. And that's, the idea behind that is to be thorough and put together a complete investigation. Correct?
Yes.
Based on your testimony and my review of your summaries, it appears that you maybe got the call on September 29th. Is that fair from your supervisor?
Yes.
And then you essentially opened up the file either that day or on September 30th.
I believe it was, well, I believe the file was opened a few days later when we got the letter of request from the prosecutor's office, but it was relatively quickly to 30th.
Yes. Okay. And it would be fair to say that we've heard some other names like Agent Rodriguez, who has a similar position with you at the BCI, correct?
Correct.
But this was mostly a case that you worked on your own from the investigative standpoint.
Yes, for the most part.
Okay. Now, from an investigative standpoint, there was almost like a handoff that occurred from one law enforcement agency to another. Am I understanding that correctly?
This was a little bit different situation that we hadn't ran into really a whole lot before, due to the time frame on when the incident took place on the 20th or the 19th to the 20th, and then our involvement, which would have been 10 days later. The sheriff's department was well already into theirs investigation, and then so there was a number of things that they had already done before we were involved.
Sure. And I guess the person who sort of have met the same description as far as lead investigator in the case prior to BCI involvement with the sheriff's department would have been who?
I believe that was Deputy Radoshek.
Okay. And he's actually a detective, right?
Yeah.
Okay. And so he was the person that would have been investigating the case prior to BCI taking over during
Yes.
those 10 days or so, yes?
That's my understanding, yes.
And the sheriff's department gave you all of the investigative summaries and notes to make part of the investigation so that you could review the work that had been done up to the point that you guys took over, correct?
Yes, we asked for them.
Okay. And they were given to you?
Yes.
Did you also communicate with other supervisory type people at the sheriff's department, even the sheriff himself?
Didn't have any conversation with the sheriff, the major, and the captain.
All right. Now, generally speaking, there's a lot of training that goes into being special agent with the Bureau of Criminal Investigation and Identification, yes?
Yes.
And a lot of that training for you has to do with how to work a case, how to investigate it, to make you more effective, right? Is there training involved?
There is training involved, yes.
Okay. Report writing training when you were first getting started?
I don't recall report writing, no, but I do have a couple of college degrees, so that's kind of where I get my writing style from.
Sure. And so generally speaking, report writing in law enforcement or detective work is an important thing, right?
Yes.
Because you want to make a written record of everything that you did in the case with all the details, right?
You do your best, yes.
And you like to make those reports as close in time to when those events that you're writing about occurred, right?
Yes,
Because memories fade over the course of time, right?
they do.
And there might be an occasion 4 years later, 4+ years later, where you have to answer questions from a defense lawyer about the things that you did back then, right?
Correct.
And so it helps to have a good record and be able to go back and review for accuracy, right?
Right.
So it stands to reason that all of the important details will be included in these reports, yes?
Yes.
Another important investigative job or responsibility is interviewing witnesses, correct?
Yes.
Okay. And again, because memories fade, that's true of witnesses as well as anyone, right? Over
Sure.
time. And so part of your training involves the importance of interviewing witnesses relatively close in time to the events that you want to talk to them about, yes?
Yes.
Okay. Now, in this case, you did conduct some witness interviews, correct?
Yes.
All right. I want to talk about a couple that I'm aware of. You interviewed one of the witnesses who testified in this trial last Thursday, Dr. Lee Lehman, the chief deputy coroner at the time down in Montgomery County.
Did.
Okay. You interviewed him once, correct?
Yes.
You would agree that based on your investigation and what you know about this case, the cause of death is an issue, yes?
It is.
All right. Spent most of last week arguing about it, right?
Right.
Now, without recapping the testimony, Dr. Lehman is someone central to that two-sided argument. Fair?
Fair.
Okay. An important witness in this case, yes?
It is.
Okay. Can you tell me when it is that you first interviewed Dr. Lehman in this case?
Like 2 weeks ago.
2 weeks ago.
would have been a week before, or 10 days before the trial, yes.
Trial started on October 30th, 2023, correct?
Yes.
Last week. So I think in looking at what was turned over to us, that recording, because you did record the interview,
Yes.
correct? I believe that recording was made on October 20th, which is consistent with 10 days before the trial, correct?
Yeah, without a calendar, that's fair.
Yeah. And so what that means is, looking back, these events, we know the autopsy was September 30th, 2019, correct?
Yes.
So 4 years and 3 weeks later is the first time that you interviewed Dr. Lemon.
Yes.
Okay. How many efforts did you make to speak to Dr. Lehman that were unsuccessful?
We made several attempts to make contact with the Montgomery County Sheriff's Department from the very beginning, because this was something that we have not really ran into before, as far as the manner and the cause.
Sure.
We don't. This is the first time in my career that I've seen that those two together in one document. We made an attempt to make contact with the Montgomery County Coroner's Office. Those initial contacts were kind of, we weren't getting much response out of them, so then the supervision of the Bureau ended up getting involved, going back and forth, to the point where we wanted to set up a meeting to discuss how all this came about. And during the course of that action, we had actually considered serving the coroner with some court service.
Sure.
To get that meeting together, but it
Never happened?
it did not happen.
Because the court service that did happen was a subpoena that was issued for Dr. Lehman, right?
Yes.
This trial.
Yes.
Right. And ultimately you reached out to Dr. Lehman, and when asked to interview, he just did that, right?
He did.
And you interviewed him for a period of about 30 minutes or so, correct?
Yeah.
And he was cooperative with you, right?
Yeah.
He answered all your questions to the best of his ability, it seemed like?
Sure.
Certainly, in your experience, an interview can be contentious, where people want to fight with you, not answer questions. This was not that, right?
That's correct.
In fact, when you asked him a number of questions, you thanked him for clearing different things up for you, correct?
That's correct.
Right. And so we know that at some point in time you completed your investigation, you turned it over to the prosecutor so they could look over everything that was part of your investigation, right?
Up to that point, yes.
Yeah. We know that there was a grand jury proceeding in this because everybody's talked about that in jury selection, not part and parcel, but we talked about grand jury, right?
Yes.
There's court process where people could be subpoenaed for grand jury, right?
Yes.
Were you ever asked to try and talk to Dr. Lehman before the grand jury or anything like that?
Was I asked?
Did you speak to Dr. Lehman or have an interview with him before that?
No.
Okay. Now, with respect to another person that testified last week, you remember Dr. Amanda Paul testifying?
Yes.
Who could forget, right?
Right.
Objection.
Now, with respect to her, we heard her testify on Tuesday, first witness out of the gate, and she informed everyone that that would never have been her cause of death, the excited delirium. You remember that testimony?
Yes.
That she felt pressured, correct?
She did.
That's what she said, right?
Yes.
Okay. And she said she was pressured by Dr. Lehman, among others, right?
Yes.
Okay. Now, you asked Dr. Lehman all those types of questions, right?
Yes.
And then we heard his testimony, right?
Correct.
Okay. Now, with respect to Dr. Paul, same question. She is the coroner who actually performed the autopsy primarily under the supervision of Dr. Lehman. You know that from your investigation, correct?
Yes.
4 years and 3 weeks. You never interviewed Dr. Paul, not even once, did you?
No.
Was she refusing to speak to you?
No, that was part of the, well, number one, we assumed that because of her position at the coroner's office that she was a full-time employee.
Yeah.
When we were having the issues back and forth with the administration in Montgomery County, and that never got resolved, it wasn't until Later on, we realized that she was doing the fellowship, and she wasn't even an Ohio resident. So for me, it was difficult. I had lost track of where she was at.
But certainly, you're the Ohio Bureau of Criminal Investigation and Identification, right?
Sure.
You have resources available to you that helps you locate people.
Well,
right?
we do have some resources, yes.
Okay. Bottom line, you did not interview her at any point in time before she got up on the witness stand.
No.
Okay. Now, she did indicate that she had spoken to people looking over at the table. If that wasn't you, you know it was who, if you know, right before testimony.
Well, it would have been the prosecution team.
Okay, meaning the gentleman sitting right here.
Yes.
And that's not uncommon for prosecutors or defense lawyers to speak to witnesses right before they're going to testify, right? You know that.
Correct.
Okay. All right. Another doctor that testified in this case so far is Dr. Burwell, yes?
Yes.
All right. Same question, just right to it. At any point in time, did you sit down and have an interview either in person or on the telephone during the 4 years this has been going on with Dr. Burwell?
We had two cases going on roughly at the same time in Richland
Yes.
County.
Okay.
I recall stopping at Dr. Burwell's office, his private practice office, to make contact with him. And after that contact was made with him, I immediately received a call from Investigator Ball.
Okay.
So most of our contact with Dr. Burwell is always directed back to his administrative staff.
Okay. But the question was, did you ever have a sit-down interview or an on-the-phone interview regarding Dr. Burwell's opinions in this case as
No.
to accident or agreeing with the cause of death for purposes of the death certificate?
No.
Okay. Have you created any summaries in this case which suggests that Dr. Burwell was refusing to cooperate with an interview?
I don't think he was refusing. I just think with his private practice, he's a busy man, so pushing some things off to his administrative staff, but no.
Okay. Now, on Friday afternoon on direct exam, you were asked by Mr. Salisbury about Dr. Roger Mitchell, who testified on Friday morning
Yeah.
into the afternoon. And if I understood your testimony, I believe you were asked and you indicated that it was you that suggested that Dr. Mitchell should be consulted with for an opinion on this case.
I'm the one that advanced Dr. Mitchell's name to the prosecution.
Okay. And how is it that you were familiar with Dr. Mitchell?
So I would call them sister agencies, whether it's the Tennessee Bureau of Investigation, Georgia Bureau, Minnesota Bureau. We sometimes will rely on each other depending on if there's a resource that they have that we don't. And in this case, the Georgia Bureau of Investigations, when I had made contact with them on a separate case, was discussing having one of their forensic pathologists, because they have on staff forensic pathologists at GBI, kind of review the autopsy, and Dr. Mitchell's name was given to me by the Georgia Bureau of Investigations to call.
Okay. And was the Georgia Bureau of Investigation aware that this was a law enforcement-based incident with an altercation between corrections and an individual at the jail?
They were.
Involved in altercation, a restraint, and a death?
Yes.
And they suggested Dr. Mitchell?
Yes.
Okay. They also make you aware that he's someone that refers typically to altercations with law
Objection.
enforcement?
Hold on, what's the basis? First of all, it would be hearsay, secondly, it's purely speculation.
What's based on what he understood and why he did what he did?
You're not operating for the truth?
No, I'm happy to let the jury consider Dr. Mitchell's.
Okay, well, ask the question, finish the question, and then don't answer until I think about it. So finish the question.
Yeah, so before you recommended that Dr. Mitchell take a look at this, did you become aware either from the folks in Georgia, your sister agency, or anything that you did on your own, that Dr. Mitchell's specific area of expertise involves law enforcement altercations with people in custody, and he has a reputation for defining those as homicide. Were you aware of that?
I will overrule the objection, but it's only being offered for what you did next, not for the truth of what you heard, but to see how you acted next, if you can.
I don't believe, well, that was quite a lengthy question, so I don't believe that I necessarily knew a lot of credentials about Dr. Mitchell until I had provided the name to the prosecution team, and then I believe that, if I can recall correctly, that there were some white papers that he had been involved with before that he had sent us to kind of look over.
What are white papers?
Like research papers, university peer-reviewed research papers.
Right. He's got a lot of those out there, right?
It appears to be, yes.
Yes. And specifically, those research papers involve topics involving law enforcement interactions, altercations with people in custody, in his position that those should be homicides when death results. You were familiar with that reading those papers, correct? At least the gist?
I don't recall the two that I read initially that he indicated homicide, but they were law enforcement in custody situations.
All right. And so, with respect to Dr. Mitchell and the evidence in this case, you recall me asking him questions on Friday about, was it OCIC? Is that the organization that you said helped with the creation of the synced up video that shows us all the different relevant angles from the booking room, including the Sony handheld?
Yes.
Putting that all into one exhibit?
Yes.
All right. You recall me asking Dr. Mitchell if he had the opportunity to review that during the several years he apparently was working the case, and he said he had not.
Correct.
You were asked on direct on Friday by Mr. Salisbury if you recall whether it was a situation where you didn't send the OCIC exhibit down to Dr. Mitchell so he could look at all those angles, or if it was the other scenario where you did, but Dr. Mitchell didn't open it for whatever reason, only looked at the Sony handheld, right?
Correct.
I believe your answer was you'd have to look at your notes to get to that.
I'm sorry, there was background noise.
It's okay. I believe your response to that was you weren't sure you'd have to look at your notes.
Yes.
We've had the weekend. You knew I was going to ask about this. What's the answer?
I actually didn't, because the physical file's up in Richfield, and I did not go to Richfield to get the physical file.
Well, did you create a summary as to your involvement with Dr. Mitchell and any discussions that you had with him along the way, or the process of sending him evidence?
No, because the original prosecution packet was sent somewhere around February of 20, and then generally what we do is once the prosecution team has a chance to look at it, then the back and forth goes as far as what they would like us to follow up on. And Dr. Mitchell was obviously one of those, along with a couple of other things, but yeah, I didn't do a summary on that.
Okay.
On that particular.
Certainly you would agree as a detective investigator with the Ohio Bureau of Criminal Investigation and Identification that the expert witness that you brought in to make an opinion on cause of death should have the ability to review all of the relevant camera angles, right?
Sure.
You thought it was important enough that this evidence exists that you got with an outside agency? Who's OCIC?
They're a quasi-division of the Attorney General's office. The Attorney General actually sits on that commission, but the commission is made up of some other law enforcement and prosecutorial members of the state.
Okay. And so this was important enough to create this exhibit that synced up everything in real time, right, with the audio. You sent it off to be created. They took time to make that exhibit, right?
Yes.
It's being shown to the jury in this case, correct?
Sure.
It stands to reason with your investigative background that Dr. Mitchell absolutely should have reviewed that, right?
Objection. I don't know if you're asking for, if it's asking for his opinion.
I can ask it different, but.
Yeah, I
that's
think
what
I
I'm asking for.
sustain it as to asking for an opinion from him.
You would agree that the purpose of this investigation was to determine the facts and circumstances surrounding this incident, correct?
I can agree with that.
And that's all the facts and circumstances, right?
Sure.
And in this case, what's clear is that the expert who was testified for the state of Ohio, Dr. Mitchell, did not consider at least one or two of the additional camera angles that show a portion of the restraint, correct?
That's correct.
Right. And as it relates to that, as you're sitting here today, I just want you to do the best you can with your recollection. I asked one time since we didn't check the notes. Do you believe that you sent that to him, the multiplex video, at any point in time during the 2 to 3 years that he was on this case, or you simply did not?
I believe it was all together.
You believe you sent it, right?
I do.
Okay. To be clear, he never reached out to you, Dr. Mitchell, and asked, hey, are there any other angles of this? I mean, it's a jail, there should be fixed cameras, things like that. Was there ever a conversation where he was requesting additional camera angles?
To me directly, no.
Did anyone come to you and say he called them and said, hey, you need to get this to him? Did that ever happen?
Not that I'm aware of.
Right, because if that had happened, you would have sent it to him, right?
Sure.
Right away.
But hopefully in a timely manner, yes.
Sure. All right. Because time's money, right?
Well, I'm an hourly employee, so it is, but yes.
Right. All right. Now, when determining the facts and circumstances, all of them surrounding this incident, there's been a lot of testimony about the involvement of illegal drugs in this case as it relates to Mr. Rios at the time of the incident, correct?
Yes.
You've heard all of that. And you were aware of that when you were investigating the case, correct?
Yes.
All right. So, your first day on the job was essentially September 30th, 2019 when the autopsy occurred, correct, on this case?
Yeah, because I did pick up the piece of evidence from John, yeah.
Yeah, it is. All right. And so, that evidence is up here somewhere, right? Sure. It's in this envelope?
I believe so, yeah.
Now, this has been identified as State's Exhibit 6. You recognize this as what you picked up that day on September 30th, 2019?
Yes.
Okay. And so, it's my understanding that you received a call from Special Agent Rodriguez regarding this evidence, or did you reach out to him? If you remember.
I don't recall how that happened.
You probably would have had no reason to know it existed unless he contacted you, right?
I think that's fair.
Okay. Bottom line, the two of you had communication,
We did.
and not so much for what he said, but for what you did as a result. Based on the conversation that you had, you learned that there was this evidence, right?
Yes.
As I understand it, Agent Rodriguez works in the southern portion of the state, right?
Out of the London office.
London office, and he was interested in getting this to you so that it could be preserved for evidentiary purposes, right?
Yes.
And so you made arrangements with him to meet him on Route 71 for the evidence transfer, the pickup, right?
Yeah, at 36 and 37.
Which everyone knows is the Delaware exit, right?
I think it's Sunbury, but yes, it's fair to say Delaware.
Okay, and so that handoff occurred, yes?
It did.
All right, and you start driving north with that, and your purpose at the time while driving was to take this to Richfield, I guess?
The plan was to take it to Richfield, yes.
And along the way, you're kind of keeping an eye on it, and you're starting to see it gas up a little bit.
Yes, it was starting to bubble.
Can you explain that again, what that means?
Yeah, so, evidence that different types of evidence and how it's packaged will, most of the time they suggest that anything that's wet goes into a brown paper bag. Paper tends to vent better than plastic. Plastic promotes mold and more moisture. So when I had looked at it initially or relatively closely after I got it, it actually started to bubble, which means that it's starting to gas off or it's starting to degrade. The best course of action is to get that in the drying chamber so it can dry out and stop that degradation process.
Because degradation, if I understand right, your concern is you got to get this somewhere where it can be dried out in a lab, because if there's any evidence of value, we could lose it based on this process, or at least there's that risk.
There is that risk.
Okay. And so to that point, you made a pit stop along the way in your old stomping grounds here in Mansfield at the Mansfield Crime Lab to pay a visit to Tony Tambasco.
Yes.
And it just turns out that they have a drying machine that they were willing to use to dry this out and keep the evidence safe until you decided you needed it, right?
Yes.
Okay. And so the Bureau of Criminal Investigation and Identification, you're the investigation part, right?
Yes.
The identification part speaks to the crime lab access that you all have there, right?
It's historical.
Oh, okay.
The identification, the identification side of that is actually pretty historical. When prior to the mid 1970s, we were responsible for keeping the identification of the state's inmates at the state prisons.
Okay. And so even though that's not really a thing anymore, you kept that.
They did. It's statutory.
Everybody calls you BCI anyways.
They
though,
do.
right? But there are a number of crime labs that are part of BCI, correct?
3.
Okay. And those are like in Bowling Green, Richfield, and London?
Yeah, and then the Springfield.
Springfield.
There's a Springfield lab that's not ours, but we do have staff there. And then for a while, Chemist Tambasco was also doing some overflow work here out of the Mansfield Crime Lab.
All right. And so one of the labs there at BCI has the capability, chemistry, to perform tests for the presence of illegal drugs or any type of drug on items, correct?
Yes, they have the ability to do that.
Okay. And if so, then they have the ability, if there is the presence of drugs, then they can take the next step, which is to identify or confirm what type of drug that is, and then even in what amount.
Sure.
Okay. And so the way this process gets initiated, if I understand it correctly, is that once a piece of evidence is in the custody safely of BCI, the way that the crime lab with BCI is triggered to perform a test is the investigator can fill out a lab request sheet, correct?
Yeah, there are some parameters depending, yes.
Okay. Generally speaking, though, crime lab's not just going to go down to the evidence room and start collecting stuff and running tests.
No.
The investigator has knowledge as to what the case is about and what tests might be helpful, right?
Yes.
Okay. And so then so there is a form that you as an investigator can fill out, submit to the relevant crime lab, and request testing on a specific piece of evidence that would be identified by like a property number, right?
Yes.
Okay. And that's the kind of thing we can see on this bag. It's identified and marked up with all sorts of different information. One of those is the property number, right?
Evidence number, yes.
Evidence
Property
number.
number, yes.
Okay. And that's so that we make sure we know what we have, right?
Yes.
All right. That's what chain of custody is and all that sort of thing too, right?
Yes.
Take great care to make sure that we know where a piece of evidence has been and that it's the right evidence that we initially collected, right?
Right.
Okay. And so, in this particular case, with respect to requesting laboratory testing to identify whether or not there were any illegal drug substances inside or on or anywhere on this described as torn or ruptured plastic bag-like object, did you ever fill out a form like that to request drug testing on this item?
To request drug testing, or did I fill a document out? No.
Okay. Now, that means that the BCI Crime Lab did not run any tests to determine whether or not there were drugs in that bag, correct?
They did not test that.
Okay. Now, on the topic of drugs, there's been a gang of testimony in this case regarding the presumptive positive for amphetamines, correct?
Sure.
You knew from reviewing the medical records and heard again during the trial that the threshold for the presumptive positive for methamphetamines is 1,000 nanograms per milliliter, right?
That's what the hospital records indicated.
Yes.
Objection. Amphetamines, not methamphetamine.
Didn't I say anything?
It's amphetamine, so if you said that, I
If I
would
did,
sustain the
I
objection.
misspoke. Well, I said amphetamines, I apologize. So, we've already been through, that sets the basement, but not the ceiling, right? The threshold
Yes.
amount?
I do believe it said less than, which for math, the caret would be pointing to the left, so it would be less than. But you're correct. That is the threshold. That's the bottom of the threshold.
Okay. And so, in this case, there's been a lot of testimony about any efforts made following the presumptive positive so that we could get some type of confirmatory laboratory test to tell us not just specifically what class of amphetamine, but also an amount that was in his system, correct? There's been testimony about any efforts made to accomplish that, or lack thereof.
Yes.
Okay. And so, one way that could have occurred is if we went to the hospital and the sample was still there, right?
Correct.
If that were the case, the sample could be collected, meaning the urine sample, right?
In this case, yes, you're
Right. And then that urine sample could be sent off to one of these BCI crime labs. And even though it's a urine sample, they could do testing on that, yes?
We don't particularly do. It's not my understanding that we normally do urine testing. Normally, that is sent to a different laboratory to do that. But
A different crime lab, right?
yes,
Like maybe the State Patrol crime lab.
yeah, that would be one of them.
Yeah, because you have experience as a patrol officer, right?
Yes,
You know that back in your days of investigating, you should probably had a number of OVI or drug driving type cases.
not a lot of them, but a few.
Yeah, and you know that when we're trying to determine what's in someone's system for purposes of an OVI, we can request breath, blood, or urine, right?
Yes,
And that if it's urine, that urine could be sent off to the state crime lab, whether like the state patrol, analyzed, and we can get levels of exactly what's in someone's urine, drugs, alcohol, and exactly how much, right?
sure.
And as long as the appropriate protocol is followed, just like we talked about in the handling of evidence, then that evidence can be admissible in that person's OVI trial as to how much they have in their system based on their urine test, right?
Yes,
Okay. And also, if there had been blood collected from Mr. Rios, if that had somehow been preserved at the hospital, that also could have been collected, correct?
could have.
Okay. Now, we know that you didn't get involved in this case until September 30th. We know that Mr. Rios had obviously already passed away. We've heard some testimony in this case that the hospital's only going to keep the specimens for several days, right?
Yeah, it's. I'm not entirely. I don't recall. I remember asking the hospital, but I don't recall if it was 48 or 72 hours. But it's a relatively short period of time.
Okay. And so when you talk about asking the hospital, did that involve you going to the hospital and speaking with staff, administration, doctors to confirm that even 7, 8, 9, 10 days later, 10 days later, that there wasn't still the specimen kept there given his condition? Did you ever confirm that?
I don't remember confirming that, but I know in prior cases that we've had with Ohio Health,
Yeah.
that's generally kind of their corporate policies
And
for ER.
yes, and we understand policies, and those are the things that people are supposed to stick to, right?
Right.
But there could be exceptions made in day-to-day life, right?
Sure.
And in this particular case, we've done all this talking about confirmatory tests and levels and all of this sort of thing. And what I'm asking you is, during the time you were investigating this case, when you first got on, or in the days that followed, did you make any effort to just to check, based on the circumstances involved in this case, to see if maybe the hospital thought, maybe we're gonna keep this around for a little bit? Was that discussion ever had with hospital staff, people that would know?
I don't recall having any conversations with the hospital, but I do know the initial. So there was we were trying to eliminate some redundancy in here from what the sheriff's department had already started in when we got in, and I do recall that the sheriff's department, the detective bureau, handed off a I'm going to call it a relatively smaller packet of hospital records to me within like a week or that first week of our involvement. And I don't recall the conversation, whether with the sheriff's department, whether that topic had came up, but I do know somewhere along the line I was informed that those vials or those samples were no longer available.
And this is the kind of thing that you're struggling to remember because it happened a long time ago, right? These
Sure.
conversations. Any summaries on this important point that just tell us what the conversations were, or the procedure that you followed, the efforts you made to make sure that these samples weren't available, these specimens weren't available at the hospital 10 days later?
Without checking the case notes, there's no documentation in the report, but the case notes may have a note in them, but not an investigative report as I think you're suggesting.
Dr. Paul got up on the witness stand and you heard her testify that my understanding is no drugs at all because he was on ADHD medication. You remember her telling the jury that? If you recall.
I don't recall that. I'm sorry.
Okay. You did investigate because there's been testimony about what a presumptive positive for amphetamines means and what it might not mean as it relates to methamphetamine. You know all that testimony in the case, right?
Yes.
And the idea being that amphetamines can show up if, say, for example, there was a prescription for something like Adderall, an ADHD medication. You know that, right?
Yes.
You knew that back then, and that's why you did an investigation while the case was still pending with respect to something called an ORS report, right?
Yes.
An ORS report is a database, ORS, that keeps track of all the prescriptions that we have in our name and how we fill them, right?
Yes.
And they can be absolutely relevant for any number of different reasons in your investigations, correct?
Sure.
Right. And it was relevant in this case because you went, and because you have access and authority to run that database, you ran what would be best described as an ORS report on Alexander Rios, yes?
I did.
And you went a couple years back, right?
I did. If I'm asked as a user to do it, I normally go back to January of the year. So there would have probably a 2-year period.
Does it refresh your recollection? You wrote a paragraph about this in your summary, right? So I want to get this right. Special Agent Lenhart, being an authorized user of the database, queried, asked, right?
Yes.
Queried about Rios' prescriptions for the dates of Monday, January 1st, 2018 through Thursday, September 27th, 2019, right?
Yes.
ORS, the database, was able to locate Rios' name and date of birth, confirming it's him in the system, right?
Yes.
However, there were no prescription records within the prescription fill dates identified above, right?
That's true.
Okay. And so, did you tell Dr. Paul that he had ADHD medication and that was the explanation for the presumptive positive for amphetamine? Did you do that?
No.
Of course not, right? You didn't tell her that, did
No.
you? Okay.
I thought there was more to it. Okay.
No, that's it on that point. Now, during your investigation, you became aware, just by watching the video and investigating, that Alexander Rios was in a single cell booking area, and he's wearing what has been described during this trial as a suicide gown or smock, right?
Yes.
And you learned that he found his way in there to that suicide smock in the single cell because at noon, the day before, he indicated to a guard intention to hurt himself, right?
I was told by the sheriff's. I was told that he actually mentioned it to another inmate, and then that inmate went to the jail staff, which prompted the protocol to move him.
So, what you learned is that he made a statement indicating an intention to potentially self-harm, right?
Yes.
Well, I'm going to object at this time. We're relying on hearsay upon hearsay.
It would be, it would only be
I can
to
refresh.
show what he did next, and I don't know that he did anything as related. It's not sustainable.
Ultimately, that's your understanding of how he ended up in that suit?
Yes.
Okay. You heard him identified as being in a crisis-type state of mind by Dr. Mitchell, yes?
Yes.
You've heard all of the other people, Dr. Lehman, et cetera, testifying as to his state of mind, as you can see on that video, right?
Yes.
Okay. To be clear, strike that. Now, with respect to Mr. Rios and drugs, you know that possessing drugs in the state of Ohio, methamphetamine, is a felony offense, correct?
Amphetamine or methamphetamine?
Objection, this calls for a legal conclusion.
If he's a law enforcement officer.
There are many factors that go into the level of a crime.
I guess you'd have to rephrase it.
I can do that.
I think you'd have to rephrase it. So I'll let you, I'll sustain it, but I want to hear the rephrase.
In your experience as a law enforcement officer, if I have what tests to be methamphetamine in my pocket, okay, and when confronted about that, I pull it out and say, this is my methamphetamine, and I'm in the state of Ohio, and they test it, and it comes back as methamphetamine, that is a felony offense in the state of Ohio, correct?
Correct.
And it goes up and down based on how much methamphetamine you have, right?
Yes.
Okay. It is also a crime in the state of Ohio to bring methamphetamine into a jail, separate crime, right?
Yes,
And that is a felony offense as well, correct?
I believe.
Okay. I want to talk a little bit about the investigation that you did into the tasers.
Okay.
It's fair to say that you did quite a bit of work on that part of the case, yes?
Actually, those also go down to the Ohio Organized Crime Investigations Commission, and they have the software to download it.
Okay.
So I work off of whatever product they send back.
Okay. And so that work would not have gotten done had you not thought it was important.
Yeah. Yeah.
Right. Because they don't know anything about it down there unless you collect the evidence and send it to them and make a request and give them information on what they're looking for, essentially, right?
Correct.
Okay. If you could you just tell the jury about the investigation that you did into the tasers, who had them, the deployment, and such? And I understand you're up there without a single stitch of paper. If you need it to refresh your recollection, I'm fine with that.
So the tasers, when we have cases where tasers are involved, we collect those tasers. If they don't, the agencies don't necessarily have to voluntarily give them over, but in this case, the tasers were collected, they were handed over to us, and then they're sent down. There's a couple of different situations that can happen. They can be sent down to the Organized Crime Investigations Commission, and they can be downloaded with the software that they have, or the agency that has the tasers. If the agencies have the ability to pull off the reports, then in those situations, the agency then can give us those reports of the operation of those mechanical devices.
Okay. And so in this case, 2 tasers were collected, right?
I don't recall. It was 2 or 3, yes.
Okay.
think it was
Would it
two.
help if you took a look at your investigative notes? I'll just bring it up there.
Yeah,
I want you to be accurate. Is it
yeah,
cool?
that's,
Okay.
please.
I'm not marking this, it's just to refresh his recollection. May I approach, Judge?
You may.
Yeah, as much time as you need, and then of course, you know, there's more details in there in a different section if you do that, but take your time, let me know when you can answer a few questions.
Yes, sir.
Okay. All right. If you would, does that refresh your recollection as to what was, how many tasers were collected?
Yes,
How many?
there were 2.
Okay. And ultimately, did you draw conclusions about whose tasers you had collected, CO-wise?
I do know, yeah, because the jail administrator advises who they belong to.
Right. And you also have reviewed the video a number of times, and you can kind of start to put that together, correct?
Yes.
And you've also reviewed same statements that Dr. Mitchell reviewed, right?
Yes.
Okay. Of the COs, right? Okay. And so let's speak first. Officer Longshore, you collected his taser, right?
Yes.
All right. Tell us what the results of your investigation were into the deployment of Officer Longshore's.
Let's see here. Make sure I get the right. You said Longshore, correct?
Yes, sir.
Particular weapon was used 4 times during the altercation with Rios, according to the weapons downloaded report. 3 of the deployments were for 5 seconds, and a single one deployment was for 1 second.
Okay.
For a total of deployment time of 19 seconds.
Deployment time of 19 seconds. What does that mean to you?
Just that the device is cycling.
Okay. And it's, in other words, in order for the device to cycle, what mechanically does the user have to do?
Normally you have to pull a trigger.
Okay. So just like a gun, a taser is held on a handle and there's a trigger that's available for your trigger finger. Is that
Yes.
accurate? You aim the taser at your intended target if you're going to use the barbs and prongs deployment, right?
Right.
And then fire with the idea that the prongs will hit the individual and become affixed in them somehow, correct?
Correct.
Now there's a conducted energy that allows for the juice or the jolt to happen, right?
Yes.
And that juice, that jolting continues until the individual who's deploying the taser pulls off the trigger?
No,
Please tell.
I'm not an expert with tasers.
Do the best you can.
It's been 18 years since I've used or had the ability to use one, I guess. They're set at 5-second.
Okay.
I call them cycles, but they're set at 5-second intervals. So they will, from when they're initiated with the trigger pull, they will run 5 seconds if you do not stop it.
Disengage.
Yes.
And is that why, in your opinion, there's 3 5-second and one that is just 1 second?
Yes.
All right. And it stands to reason that there would be this like 5-second limit to keep someone from tasing someone indefinitely.
Yes.
Right. Okay. All right. Now, it was this taser that we could see on the video that your investigation confirms that Officer Cooper was struck with in the webbing of his hand, correct?
Yes. Well, I would have to assume that because of the cycle times.
Okay.
I do recall that if I recall the video correctly, the first deployment that actually had the cartridge in it with the bay doors, it did cycle through, I believe, for the 5 seconds.
And that happens based on your review of the video and all the evidence in the case. That happens just as soon as Officer Cooper enters the struggle, right?
Yes.
Okay. In other words, it's all already underway by the time Officer Cooper responds, correct?
Yes.
And the first thing that happens to Officer Cooper is the taser's deployed and he gets hit in the hand, right?
Yes.
And I think your question about this, he walks away, seemed kind of pulling at the wire, right?
Right.
Okay. You know from your investigation that Officer Cooper went to the hospital after this, had his hand looked at? That,
Yes.
yep.
Well, I was made aware of that, yes.
Well, you've reviewed all the statements and all the evidence in the case, right?
Yes.
And people talk about it, and that's in those statements, right?
Correct.
Been tased as part of your training, ever?
It's been a long time ago.
Right. But that has happened to you?
Yes.
Describe it as something that is painful,
Sure.
something that can have some lasting effect,
On your memory, yes.
right? The prong itself, were you tased where the prong was stuck in you?
I believe it, yeah, it was
Or was it a
right
drive
hand.
tase?
It was,
dry
no,
stuff?
he had a barb in his hand.
What about you when you were tased?
Oh, no, we used alligator. It was a makeshift alligator clips on the back of it.
So,
Those are expensive, so in order not to keep buying for training, they have a separate device that it clips on your shirt.
right. It's also makes it so you don't have to be fishing a probe out of the person, right?
Yeah.
With respect to Officer Prendergast, his taser, what can you tell us about that? When watching the video, we can see that Officer Prendergast kind of removes his cartridge, right? You recall that?
Yeah, there was a cartridge laying there. It did look like the bay doors didn't appear to be removed from that one. This particular weapon was used one time during the altercation with Rios. Single deployment lasted for 1 second.
Okay. All right. And so what is the difference between a drive stun or a dry stun? I've heard it described both ways. And the deployment that involves the barbs or the cartridge.
What's the difference?
How's it work?
So
We talked about how it
Excuse
works.
me, Your Honor.
Yep.
Can we clarify whether this is based on Special Agent Lenhart's experience? He's already testified he's not an expert on tasers.
It'd have to be based on your training experience with tasers.
Do you have familiarity with what drive stun mode is?
yes.
I'm not asking for an expert.
Okay. Yeah, I'm okay with it as long as he's talking about what he knows
Sure.
being a law enforcement officer. But I don't want him talking about it and giving opinions that would require him to have some information or education beyond his experience working for BCI and his prior law enforcement experience.
Your Honor, for purposes of the record, the question that was originally asked was, what's the difference between these two types of use of the taser? I believe that calls for a level of experience in an opinion that goes well beyond Special Agent Lenhart's
I guess I just
level of
disagree
knowledge.
with that.
I guess, I think he can talk about it based on if he's trained with him, if he's been tased before as part of his training, if he ever had one. So I think you can get some foundational questions to help us out, but I think if he can do it that way, I'll allow it, but I think he needs more foundation.
Based on your experience with the Mansfield Police Department and as a special agent, do you have familiarity with the use of tasers?
Yes.
Okay. And do you have some degree of training with respect to the use of tasers?
Yes.
Okay. Do you have familiarity with there are, I guess, essentially two different methods or manners by which you as a law enforcement officer can deploy your taser?
Yes.
We talked about method number one about 5 minutes ago with respect to aiming and shooting the prongs into someone and then conducting the electricity through wires, right?
Sure.
Is that one method?
Yes.
The other method that I was starting to ask you about is the so-called dry stun method. Are you familiar with that based on your training and experience?
Yes.
Can you tell us what that is?
That's when the cartridge in the taser is removed, the connectivity points that actually trigger the bay doors and the cartridge that shoots the prongs, that will also conduct the electrical current. So without the cartridge and with the prong shooting out of it, you can actually place it on skin and activate it and get an electrical response out of the unit in that form and fashion. So where the first method that you had asked me about is a distance. So if you have a distance between you when it's deployed, as opposed to when you're close, those taser barbs are not going to deploy properly if the cartridge is still in the taser and you're holding it up to somebody's skin.
Okay. So it's an alternative use
Yes.
to bring about essentially the same type of result, right?
Yes.
All right. And it's essentially what amounts to either method is a pain compliance is a use of electricity to gain compliance through a pain technique. Pain, I can't think of the word that I'm looking for.
Yes.
Okay.
Pain compliance.
Yes, right, okay. The idea being people don't like being tased, so whatever they're doing, they'll stop doing it so that they can be gotten under control, correct?
You hope.
You are? Yes. Now, with respect to video, booking room isn't the only area in the jail that has these types of cameras, right? Meaning security cameras.
I believe the whole jail does, yeah.
Right. And so the eye in the sky, if it were, is kind of following you all throughout the jail during your stay if you're an inmate, correct?
Yes.
Okay. That includes when you're brought into the jail during the book-in process, you know that the Richland County Jail has a body scanner, correct?
That I was not aware of.
Not aware.
No.
Do you know what a body scanner is generally as an investigator with the Bureau of Criminal Investigation and Identification? In the jail setting, generally speaking.
In the jail setting, no. I'm not familiar with those scanners.
Would it surprise you to know that they have that kind of equipment in a jail so that they can run people through it, get a look at what's inside of them, imaging?
Your Honor, I'm going to object again. Now, Mr. Mayor is testifying because this witness has already said he has no familiarity with that machine.
Yeah, I don't think he knows, so, I would sustain it as far as his knowledge. He doesn't know what they are. He may know that they exist, but he doesn't know what they do, so I'll sustain.
Did you make any inquiries in this case at the jail, whether with the administration, the sheriff, or any of the people that you spoke with as to whether there was any technology in the jail that they're run through inmates to make sure they're not bringing contraband into the jail? Did you make inquiry into that?
Advanced technology like that, no.
May I approach?
Yes.
Agent Lanhart, I'm going to show you what's been marked as Defendant's Exhibit F. If I were to play this, it would be one of these body scan videos showing Alexander Rios heading through the body scanner and the time leading up to that.
Okay.
Have you had an opportunity to review that now that you
No,
know
this video was not made. This video was not provided to me when the rest of the videos were given to me.
And so what you're telling us is that Alexander Rios being booked into the jail, going through the body scanner, is not something that you've ever had an opportunity to look at
I have
as part of
not.
your investigation.
I'm not.
You know that there's been discussion about drugs in this case, right?
Sure.
Whether or not he was under the influence of drugs or not, right? You know that generally speaking, drugs in jails are problematic, right?
Sure.
And so it would be important to your investigation to take a look at that type of evidence to see if there was anything concerning or suspicious regarding Alex Rios's process of going through that scanner. That would be relevant, right?
Yes.
Something you'd like to see as part of your investigation?
Sure.
Would you like to take a look at it right now?
Yeah.
Approach.
Dan DeRosa with 19 News. As the judge wants to speak with the attorneys, it certainly appears that the defense, for the second time in this trial, is about to announce new video that has not been previously seen. On the stand is an investigator with BCI, that's the Bureau of Criminal Investigations, who was basically overseeing this entire process and the investigation into the death of Alex Rios. So the fact that we're about to see video that the lead investigator himself has never seen is very intriguing. And the video that he wants to show, apparently, is in the booking process of Alex Rios. Earlier, we saw the testimony, as we see there, the man standing trial here, that is former corrections officer Mark Cooper. The reason he wants to show this is it goes back to that piece of plastic evidence that was taken out during an autopsy of Alex Rios. and exactly what was in that piece of plastic. We heard the defense already start to poke holes. Remember, that's all the defense's job is, to create doubt in the minds of the jury. Remember, guilty beyond a reasonable doubt. And if they never tested that piece of plastic, and it's the defense's contention that that was full of methamphetamine that Alex Rios swallowed so that he wouldn't be caught with it. Now, we heard him on this exploratory questioning of the BCI agent. Did you ever test that? No. Have you seen the booking photo to see if he did anything suspicious? Now, if this defense starts to play a video of the booking process, so the first time Alex Rios is brought in handcuffs, if they somehow have a video of him taking a plastic bag and swallowing it, and it's caught on camera, that would go a long way in the mind of a jury that this idea of the excited euphoria, let me get the exact term, that they think he died from, go back one more page here, excited delirium, this notion that you can die if you have drugs in your system and you get to this excited state. If we see video of Alex Rios in the booking throw a piece of plastic bag in his mouth, that is going to go a long way. We can see the defense here debating. He has two lawyers, Mark Cooper has two attorneys, both those gentlemen there. And so it will be interesting to see if the judge will allow them to play this video or not. I can't see where the argument would be of why the judge wouldn't allow this video from the booking center.
So you've mentioned several times the prosecution team in this case during your cross-examination this morning, correct?
Yes.
And you're essentially working alongside the prosecution team in this case, right? You're sitting at their table.
Yes.
Okay. And so you are familiar with the information that the prosecution team has put together in this case, whether it's what you provided or has come to them, correct?
I know some of it, I don't know all of it.
All right. And so what you're telling us this morning is that when I approached you with the exhibit with the purpose of asking you questions about it, an exhibit that purports to be the body scan process at the jail of Alex Rios, you're indicating not only have you've never seen it, right?
I've not seen that.
You're also 100% unaware that it was a part of the prosecution's team evidence or what they have in their possession.
I don't recall I don't recall seeing that video of his booking. I recall the written documentation of when he was brought in. There's like written reports or the checklists that COs do, but I do not recall seeing a video of any scanning devices.
All right. But you would agree on the issue of drugs or not drugs in the jail, that process would be pretty important to take a look at in your investigation.
If that process detects drugs in the scanner, yes.
Or if there's any movements going on that would be suggestive.
Again.
Objection.
All right, I'll move on.
Okay.
All right. Did you make any efforts to obtain video during the 8, 10, 12 hours that Mr. Rios was in the pod setting, the general population area, before being moved down to suicide watch?
No, because once again, our involvement was, obviously 10 days later, and he was already down into the booking area at that time. So no.
Okay, so I just want to be clear. What I'm asking is, you did obtain video from the booking area, obviously.
Yes.
And that was 10 days after the event that it came into your possession, correct?
Yes.
Did you make any effort to obtain video from the time that he spent in the pod prior to being transferred down to the booking area?
No.
We have one moment, Judge.
Yes.
So there was clearly a problem with this idea of wanting to show the body scan portion of the booking process, that the judge did not allow it. My guess, and of course this is just a guess because weren't privy to the conversation between the judge and the attorney, is that there is, and you heard him, there was an objection when the defense attorney said the process of...
I appreciate you answering my questions so far this morning. That's all I have at this point. Thank you.
Redirect Assistant Prosecutor Salisbury?
Yes, thank you, Judge.
As we get a redirect now from the prosecution, my guess is that he was going to try and imply that there was some movement or, maybe nothing that was definitive of Alex Rios swallowing anything. And of course, in a court of law, you cannot imply or infer anything. It must be concrete.
Preserve the urine and or blood that was obtained at the hospital from Alexander Rios.
I'm sorry, can you?
Well, did you have knowledge that by the time you got involved that those samples were gone?
Yes.
Okay. And is that the reason why you didn't do anything further? There was nothing to do because they didn't exist, right?
Right.
Okay. Would you have done that had they been available?
But yeah, you always like to try to get that stuff because that's kind of a key piece.
Okay. And
If I may, each hospital system is different on their lengths and time. So
sure.
yeah.
Okay. And in this case, you knew they were gone.
Yes.
Simply put. Okay. The item states exhibit number 7 or whatever it was, the thing that was removed from Mr. Rios' stomach. Tell us the reason why you didn't request that that be tested for drugs.
So when Agent Rodriguez and I had met at Office 71 there in Delaware, Sunbury, he had indicated to me, and actually I believe the sticker on the outside of it also said removed from the gastric contents. Mm-hmm. And so relatively speaking, I guess, even though Mr. Rios was in the hospital, we know Mr. Rios was in the hospital for 10 days.
Objection and ask to approach.
Yeah.
For 7.
And again, we're going to get another sidebar discussion between the judge and the attorneys. There have been a lot of these in this trial, an inordinate amount of sidebar issues because of, and I think this only helps former corrections officer Mark Cooper. There are a number of items that, even from, I'm not an expert, the fact that that piece of plastic that was taken out of his stomach was never tested for any substance. Was that a baggie of methamphetamine? Did he ingest meth in a whole form at some point during that night that he was arrested, then the struggle, and could that, along with the struggle, the body full of methamphetamine, could that have led to the cause of death? The fact that it was never tested is kind of an issue. And so the defense has brought it up a number of times. You've been listening to the prosecution now trying to say, well, you didn't test it because it was 10 days later that you got that piece. Because remember, there is the struggle in the jail. He is unconscious and blue at the jail. He is taken to the hospital where he spends 7 days in the hospital on life support and then dies. It's only 3 days after that that the autopsy is performed, or 1, 2, or 3 days after. It's on that third day that this BCI detective is given that piece of plastic. And so he is trying to say the reason we didn't test it was because, well, it was 10 days later. And it would be speculation to say whether it would or would not come back positive for any methamphetamine. We also saw the defense poke a hole and ask, well, did you ask the hospital if they had kept any of his urine by the time you had gotten on this case? Because couldn't you test the urine to see what levels, but again, it would have been 10 days later. But he said no, they did not ask the hospital. They were not given any urine from the hospital. They did not collect it. As you heard the detective say, every hospital system is different on how long they hang on to samples like that when someone has passed away. Again, all the defense tried to do here is poke some holes, put in some doubt into the mind of the jury. They didn't test the plastic baggie for meth or whatever that piece of plastic was. Interesting, I learned something today when the detective said he first picked up the sealed plastic bag that had that piece of plastic in it, that it started to bubble up and form gas within that sealed piece of plastic. I didn't know that that could happen. It looks like we're going to get back to our testimony now.
Experience as a law enforcement officer, and then if he offers that someone told him something, again, ladies and gentlemen, what somebody told him would be hearsay, so it's not admitted for that that's actually the truth, but it would be admitted to show why he either did or did not do something thereafter. So if you can answer those with those two stipulations, I'll allow it.
So Agent Lanehart, again, I'll ask, why is it that you didn't request that that item be tested for drugs?
My training and experience as a law enforcement officer also allowed me the opportunity to become an advanced emergency medical technician in the state of Ohio. So I do have a little bit of knowledge about basic knowledge about human anatomy. This item sat in Mr. Rios' stomach. That's where it was taken out of. At least I have to believe that the doctor's report. And there are acids. Our stomachs are very acidic. So after getting treatment for 7 days, it's more probable than not that the acids in the stomach degrading not only potentially the item that it came out, but also any substances that were on it would more likely than not been either inconclusive or negative.
Okay. You are, well, let me ask you, are you familiar with the use of force policy at the Richland County Jail?
Just from, yeah.
From here in this courtroom?
Yeah.
Right? Okay. That is a policy, not the law in the state of Ohio, is that correct?
I'm going to object to that.
Okay.
That's the approach.
Yeah.
And here we go with another approach of the bench, an objection by the defense team here in the questioning about the policy and the use of force by that particular county jail. We're talking about the Richland County Jail. Again, yet another objection. This case has been full of these objections and sidebars. It shows the complexity of the trial. And again, I think all of this works in the favor of the defendant because all his team is trying to do is put doubt in the minds of jurors. And if the attorneys can't agree on what can and cannot be said on about an every 5 to 15 minute basis, that is very telling for a jury that, wow, there's so much at stake here. There are so many minutia, these little details here that need to be debated on such a continual basis that's what we're dealing with here. I'm going to give you a warning again that we're going to show just a clip of the video that's at stake here for former County Corrections Officer Mark Cooper. This is tough to watch because this is the restrainment of Alex Rios. Take a look here. You can see Rios's head is being pushed to the ground. He is still fighting, being cuffed. And you see right there, the weight of Mr. Cooper is now standing on the back. He does it again. It's for a total of 7 seconds. that he puts his full weight back there. Part of this trial, and you see then he kneels back down on the back upper neck of Rios. He would turn blue, he would lose consciousness. They did call the EMT, or what they call the squad, and he is taken to the hospital. He would survive for 7 days in the hospital before dying as an ultimate result of this. The investigation was a little slow on the uptake because it was a judgment call within that sheriff's department and about how far to take this. That's why we constantly are hearing, and we heard from the first BCI agent that the first time he was called to get involved with this case was in the middle of the autopsy with Mr. Rios. He said he was a little taken back when he got to the autopsy, that the doctors and the coroners at that facility were a little confused as to why BCI was showing up to the autopsy, something that would normally be standard. Let's say we know that BCI is now required to handle all investigations where an officer uses their weapon, their gun, and shoots and kills a suspect. BCI is immediately called in and would be standing there for every second of that autopsy. So for the fact that BCI showed up in the middle of the autopsy, and they asked the detective, you know, how did you know that the autopsy was underway? And he was a little hesitant to answer the question, and he said, well, they said, was it because his body had already been opened up? And he said yes, and that he was a little surprised at the fact that he was, it's not that he was late, it's that the autopsy had started right away. So there are a number of instances in this case that, and I'm not an attorney, I'm not an expert, but I sit through enough of these from the perspective of a juror, and that's what we always ask you to do at home. Put yourself in the shoes of the jury here. You get all these disruptions, you get all these arguments by the defense and the prosecution there standing at the judge's desk there, the judge's bench, and then you have all these other factors. BCI was late to the autopsy, and not late, they were joining the autopsy in process. Nobody tested that piece of plastic, that baggie, and we just heard from the BCI detective who says he has a little bit of knowledge of anatomy, that 10 days later, the fact that testing a piece of plastic that had been in someone's stomach for that long would not result in anything.
Everybody back in 10 minutes. We'll continue to talk up here.
And now we're going to get a 10-minute break because this discussion is continuing between the judge and the attorneys. This is really just one of those situations that is a little bit unprecedented, and the judge is going to make us turn our camera off here in a second, I believe, unless they go back on the record. They're clearly having the jury escorted out here, that they need to have a bigger discussion between the attorneys, the defense, and the prosecution. We'll see if they do that on the record. If they do, we will let you in on that. We'll let you watch. Some of these get pretty contentious when the jury is not in the room, and the attorneys can really let loose and try and make their argument one way or the other on whatever this issue is. And this issue is really surrounding two things here: the baggie, why it was never tested, and why this BCI detective never asked the hospital for any kind of urine or any kind of sample that was taken from Rios in the 7 days that he was in the hospital. And as they continue that line of questioning, it's getting pretty contentious. Obviously, some objections made, and they're having to go on to a bigger discussion. We're still looking at shots of the ceiling here, which tells me that we may be losing this feed altogether. But in the meantime, Let's listen to from Friday, our reporter covering the story, the synopsis, because the other thing at stake here, aside from what looks like a couple of missteps, I'm not going to call it a botched investigation, but a couple of missteps that have been clearly pointed out by the defense along the way. On top of that, you have the original coroner who did the report and called it that excited delirium was the cause of death and that the ultimate manner of death was accident. That was the original testimony from the original coroner. But then the prosecution brings in an expert from Washington, D.C., who was not a part of the original autopsy, but reviewed the autopsy that was done, reviewed the video of Rios being pinned to the ground, and then came up with his own estimation at the cause of death, and he would have ruled it a homicide. It was a very big turning point. So let's take a look at the story from Friday, encapsulating that day's testimony. Take a look.
Most of today consisted of testimony from Dr. Roger Mitchell. He's one of the world's leading experts in forensic pathology. The prosecutor thought he'd bring a lot of credibility to the case. Mitchell works with the CDC to help coroners around the world to verify whether the cause of death is accurate in their autopsy reports. He was called to testify about what he believes led to the death of Alex Rios. Former corrections officer Mark Cooper faces charges of manslaughter and reckless homicide in this case. He remained stoic while taking notes during the testimony. Mitchell had previously been asked to watch the videos of officers restraining Rios and review all of the evidence that was available to coroners when they wrote the report. Mitchell did not agree that the death was accidental or due to excited delirium.
I wouldn't have diagnosed him with a methamphetamine overdose because of what we saw in the video. That absolves any drug reaction from its effects on a human when you stand on their back until they can't breathe. The cause of death is asphyxia due to compression of torso and neck, complicating violence, subdual, and restraint by correction officers. I have this manner of death listed as homicide.
The defense attorney then tried turning the tables on Mitchell by showing him never before seen jail video of the incident. The defense didn't have much to say about that new video, only to point out that experts testifying for the prosecution hadn't seen it. Later this afternoon, the Richland County coroner took the stand. He's the last one who signed off on the death certificate. In the newsroom, Mike Mason, 19 News.
And we're going to continue our gavel-to-gavel coverage. I'm keeping an eye on our shot here still of the ceiling, and we are not getting any audio from the courtroom, which says this is not on the record that's being discussed there at the time. We have a clip of that video that was not seen before, and there was discussion of it by the defense again today. And the defense really wanted to play a new portion of the booking photo. It's the body scan that would have happened when Alex Rios was brought into the booking center there at the Richland County Sheriff's Department. The idea of would that body scan have shown Rios that he had any device on him or any baggie or any drugs on him. That's the intention for this. And then it almost sounded like the defense wanted to show it and say, you know, would you notice any particular movement? Would that be important in your investigation if Rios made any movement towards his mouth? And that was objected to because apparently it's not in the video. The defense then doesn't show the video. You don't want to put something up for the jury and say, here's a major piece of our evidence, the body scan portion of this, and did Rios make any motion that he was getting rid of anything? And you don't want to say that that's a big piece of evidence, and then you show it to the jury, and they're like, that didn't show anything at all. That's a strike against you. It shows a little bit of a hole in the case, so that's why that wasn't shown. But here is a new angle of the struggle itself. You're going to watch Rios break out, and it's as they open the door to go in and put cuffs on him. Look how quickly he escapes and runs. and gets to a different area, and this is where the struggle then starts. And that was the video that was shown on Friday, this quote-unquote new piece of evidence that had never been shown and hadn't been shown to the jury and a couple of the investigators. So you heard the BCI investigator say there were a couple of portions of video that he did not see, that he did not request. While we wait for this break, I think because it is such an important part of this case, when they have an inmate who looks like they could be harming themselves or could be destructive in a holding cell. This is already an individual in Alex Rios that is wearing the green suicide protective vest, and you're going to see him acting erratically, standing on a half partition of a wall. They've been giving him commands to get down, to put his hands through the food slot so that he could be handcuffed, and then they could go in and restrain him and put him in a restraining chair. But I do want to warn you, this is tough video to watch. This is graphic. It is video of the inmate being pinned to the ground and ultimately what would lead to his death 7 days later. Let's take a look at the video. And the reason we have this is that whenever officers attempt to restrain an inmate, especially correction officers, they will get out a camera to be able to be used as evidence in cases exactly like this, whether it's to exonerate corrections officers or to find them guilty. This is important video to have, more than just body cams. This is someone standing there with a camcorder. Take a look at the video. Again, last warning, this is tough to watch.
What's his last name again?
Rios.
Rios, I need you to come down so we can...
You were supposed to let me know this morning.
All right.
Call the law.
All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore.
What do you mean?
Okay.
I'm not supposed to be in here.
We're going to put you in a restraint chair for your safety due to not listening and being on a divider, causing a risk to harm yourself. We don't have time to continue that all night.
There's no reason
Okay.
for it.
All right, this is the last time I'm asking, then we're going to go in. We're going to go ahead and put you in a chair.
Why can't you just open the door?
Right here, go. All right, come on down.
Do that, CO,
No.
Handcuff.
Is that a yes or no?
I'm supposed to be
Go ahead and turn around, put your hands behind your back, and cuff up for me. If not, we're going to come get you.
No need to.
All right.
You guys
No.
are wrong, man.
Okay, we're coming to get you.
Ready?
Let's go. Go. Cuff your back. Hands behind his back here.
Come on, man. I'm not even fighting.
Use your taser.
I'm not fighting.
Baby.
Taser.
Fighting.
Take it off.
Taser.
Taser, taser, taser.
I'm not even fighting.
Glasses, let me get my goddamn glasses off. Taser.
Ow! 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 All right! Ow! Ow! Can someone
Try tasing.
Can you explain to me? Because you're a dumb.
No, you're the dumb.
I didn't say you were.
Got out of the cell.
Really?
Yeah, he's looking.
Oh! Ah!
Give me your hand behind your back.
Ah! Ah!
Somebody take it.
Ah!
He's on some type of drug, I believe.
Keep playing.
You need to. We have anybody else available?
I got this, man. You got it?
Rios? Alexander Rios. Alexander Rios.
Oh, that's the one that there's something going on last night, wasn't it?
Yeah, he thinks he's supposed to be out of here, and he wouldn't get down off the wall.
Turn it off. Turn it off. I would like to help.
Let go of the cuff. Ow. Let go of the cuff.
Right up there on the wall.
That's right. Pull that thing out and come out.
Get a pair of shackles.
And we got another handcuff. Where's the other hand? I got it. Where's that? Behind me, I only have one hand, guys. I can't hold it.
Do you want a pair of shackles?
Okay.
Well, I
Somebody get
can't
beside me. Nino, you're
Buck.
gonna have to get up. All right.
Grab some. Oh, he's got them.
Cooper, you ready?
We got shackles.
Ready?
All right.
Down.
Shackles.
Give me the other hand. Bring it towards me, guys. You got it?
Shackling down there.
This cuff.
Those are too big?
Give me 1 second. Where's the regular size?
Is that gonna be too big? Go slide his foot out there?
Well, we got
Try it.
That might be able to cinch up around his ankle. Do his ankles now, so. Keep going. Hey, Gardner? Yeah. Come on the other side of Long. Yeah. When we come up, we're going straight up into the chair. All right. Cooper, I'm behind you. And Long is behind you guys. I got you. Yes, all right, I got the chair so it doesn't move. Okay. You two ready? Rolling. He's turning. Straight up. Hear me? Get up.
He's turning blue.
Get up.
Call the squad. Master Control, call the squad.
We need turn him on the side. Turn him on the side. Laying down on the side. Lay him on the side.
Try to get us some oxygen, make sure everything's going okay for him.
Get the AED.
It is tough video to watch, that goes without saying, especially considering that it would be 7 days later that Rios would die in the hospital. There is a debate, as you would expect in a courtroom. You can get an expert, you can hire experts to testify on just about anything. I've covered enough trials that if you need an expert to say something is black, you can bring it in and they will say it's black. Then the other side will bring in another expert to say, no, that's white. So it is what happens in a court of law. It is up to the jury to take all that information and decide what is true or not. You have two sides, one saying that this was excited delirium, that is in fact a term that's no longer used. Remember, this is back in 2019. This investigation has been lengthy, and it's really the family of Rios that has been fighting for this trial and for this day for some time. You have Mr. Cooper, Mark Cooper, who was the bald corrections officer that was had his foot on Rios's back, and then in this instant, we'll show you. This is where he's going to lift his foot up, and he will now be putting the full force of his frame, listed at 260. You see right there, he's putting all of his weight on the back of Rios. He'll touch his foot down just briefly and go back up. And then it's 30 seconds later that he then gets down and uses his knee into the back of Rios. During this struggle, you'll see right here, he'll move positions to put that in there. So this is the dilemma here. What are you going to believe as the jury? Was this excited delirium? Was this drugs in his system put into a heightened state, which then caused his death? Or are you going to believe the expert that was brought in to testify, a man who's watched the video and who reviewed the coroner's report? Let's remember, he in no way, shape, or form performed the autopsy. That's a big difference here. Generally, if a family believes very early on that something wrong has happened to their family members, some other cause of death, they can ask for their own private autopsy. Well, that wasn't the case here. You had the one done, which would have been somewhere between 8 to 10 days after Rios had died, and just a situation that we are in now here at the trial. Again, former corrections officer Mark Cooper being tried for manslaughter and reckless homicide. We are still on break here, a rather lengthy break from the trial here. For those of you who have not seen this as of yet, we're going to play Mike Mason's story that really sort of wrapped up everything that happened on Friday, and you'll see that expert testimony, the expert that was brought in by the prosecution to say that no, this was homicide, this was not an accidental death, that this was homicide, and I believe he uses the term asphyxiation. So let's look at Mike Mason's report from Friday evening.
Most of today consisted of testimony from Dr. Roger Mitchell. He's one of the world's leading experts in forensic pathology. The prosecutor thought he'd bring a lot of credibility to the case. Mitchell works with the CDC to help coroners around the world to verify whether the cause of death is accurate in their autopsy reports. He was called to testify about what he believes led to the death of Alex Rios. Former corrections officer Mark Cooper faces charges of manslaughter and reckless homicide in this case. He remained stoic while taking notes during the testimony. Mitchell had previously been asked to watch the videos of officers restraining Rios and review all of the evidence that was available to coroners when they wrote the report. Mitchell did not agree that the death was accidental or due to excited delirium.
I wouldn't have diagnosed him with a methamphetamine overdose because of what we saw in the video. That absolves any drug reaction from its effects on a human when you stand on their back until they can't breathe. The cause of death is asphyxia due to compression of torso and neck, complicating violent subdual and restraint by correction officers. I have this manner of death listed as homicide.
The defense attorney then tried turning the tables on Mitchell by showing him never before seen jail video of the incident. The defense didn't have much to say about that new video, only to point out that experts testifying for the prosecution hadn't seen it. Later this afternoon, the Richland County coroner took the stand. He's the last one who signed off on the death certificate. In the newsroom, Mike Mason, 19 News.
And we can now report that the jury has been sent to lunch. Add that as the next curious piece of this trial that has been really almost sort of discombobulated the whole way through. This is about as early as I've ever seen a jury sent to lunch at 10:50. They've only been hearing testimony for an hour and 50 minutes. So I think what we're going to do is we will take a break as well. Wait, I'm going to double check on this because I'm starting to see our shot come back up. Perhaps we have not gone to lunch. Stick with us here. We're sort of at the mercy of our camera that's in the courtroom. I would say that I was very curious if they had in fact gone to lunch, but the fact that our camera is back up tells me that we may be going back to testimony. So stay right here with us as we wait for the continued trial in the former Richland County. We're getting some movement from our camera, which is telling me he's putting it to the ground, which may in fact tell us we have lost that shot, and we are in fact now at lunch. Again, folks, we're at the mercy of the camera in the courtroom. We are going to take our break as well. We're just going to put up our slate. For those of you that are watching on various platforms, if you are watching on one of our platforms where it is cut out entirely, and we're going to get a note here, 10-minute break, we're going to finish with lunch. So we are not, in fact, now going to lunch. We are in our 10-minute break, which is on top of the previous 10 to 15-minute break as we are waiting for the testimony to resume, and then we will go to lunch. For those who may not have seen this, and let me finish this first of all, we have our 11 o'clock news coming up, so we're going to have to switch some of our devices here. So if suddenly you're watching our stream and it cuts out, that means you can go to cleveland19.com, click on the Richland County Corrections Officer's trial, and we will be live streaming in there. If you're on one of our platforms, maybe Facebook, one of the other digital platforms, and this stream continues, then you won't have an issue. But if suddenly here in the next few seconds this cuts out, go to cleveland19.com and you can resume watching there. But what we're going to do in the meantime is let's show the video. Even though it is tough to watch, people still have questions about it. And if you're watching this and putting yourself in the shoes of the jury, this is really the most important piece of testimony here, the most important piece of evidence. You get to see Rios in his cell. From what we have heard from testimony earlier, he is acting erratically. He is potentially in a situation where he could harm himself. You will have to answer for yourself if you think that's true, the way he's acting in his cell. And then he was actually the supervisor at the time. He's the one holding the camera, and then you'll see as they get Rios to the ground, he hands off the camera so that he can get involved in trying to restrain Rios. But it said on the stand that split second when they open the door and Rios bolts out of there, he said in his 20-plus year career, he has never seen anything like that, never seen an individual move that fast and get out of a cell into that booking area. So make sure you pay attention to that. Here's another thing I want you to pay attention to. When we get to the end of this video, you'll see the bald-headed corrections officer. That is Mark Cooper. He's the one on trial here. And we're seeing our shot come back up. So perhaps we're getting close to testimony. If we do, we'll bring you right back to that. But as you watch towards the end of this video and you see Cooper with his foot on the back of Rios and then he puts all of his weight on Rios, I want you to ask yourself this. If you're on the jury, why are the 4 other corrections officers who are in various positions on Rios, one a little bit further down the back, there's a couple on his legs, why are they not being charged with anything? And if you are the jury, how does that weigh in your mind? Why is it just Mark Cooper? Is it because he puts his full weight on there? And why not the other corrections officers? Let's show you the video. If we get back to testimony, we'll cut it short. Take a look.
What's his last name again?
Rios.
Rios, I need you to come down so we can.
You were supposed to let me know this morning.
All right.
Hold the law.
All right. I'm not going to call anybody unless you come down from down here. Okay, this is the last time I'm going to ask you. I've asked you for like 5 minutes. I'm not going to do it anymore.
What do you mean?
Okay.
I'm not supposed to be in here.
We're going to put you in a restraint chair for your safety due to not listening and beyond the divider, causing a risk to harm yourself. We don't have time to continue that all night.
There's no reason
Okay.
for it.
All right, this is the last time I'm asking, and we're going to go in. We're going to go ahead and put you in the chair.
Why can't you just open the door? Right here,
All right. Come on down.
Do that, CO,
No.
Handcuff.
Is that a yes or no?
I'm supposed to.
Go ahead and turn around. Put your hands behind your back and cuff up for me. If not, we're going to come get you.
All
right.
You guys
No.
are wrong, man.
Okay, we're coming in to get you.
Ready?
Let's go.
Go.
Cuff your back. Hands behind his back here.
Come on, man. I'm not even fighting.
Use your taser.
I'm not fighting. Baby.
Tasey.
Fighting. No, dude, take it off.
Taser.
No, taser, taser. I'm not even fighting him. Ow! 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 Glasses, let me get my goddamn glasses off. Taser! Ow! 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 All right! Ow! Ow! Can someone
Try
explain?
tasing.
Can you explain to me? Because you're a dumb.
No, you're the dog.
I didn't say you were.
Got out of the cell.
Really?
Yeah, he's looking.
Oh! Ah! Give me your hand behind your back.
Oh.
Ah! Somebody take it.
He's on some type of drugs, I believe.
Keep playing.
You need to. We have anybody else available?
I got this man. You got it?
Rios? Rios. Alexander Rios.
Oh, that's the one that they sold the warrant on last night, wasn't it?
Yeah, he thinks he's supposed to be out of here and he wouldn't get down off the wall.
The safety.
Cut it off, cut it off.
Turn it off.
I would like to help.
Let go of the cuff. Let go of the cuff.
Right up here on the wall.
I try to pull that thing out when it comes out.
Get a pair of shackles.
And we got another handcuff. Where's the other hand? I got it. Where's that? Behind Nino. I only have one hand, guys. I can't hold it.
You want a pair of shackles?
Okay.
Well,
Somebody
I
get
can't
beside me. Nino, you're
Buck.
gonna have to get up. All right.
Grab some, oh, he's got them.
Cooper, you ready?
We got shackles.
Ready?
All right,
Down.
shackles.
Give me the other hand. Bring it towards me, guys. You got it?
Shackling down there.
That's cuffed.
Those are too big?
Give me 1 second. Where's the regular side?
Think that's gonna be too big? Let's slide his foot out there?
What we got?
Try it.
That might be able to cinch up around his ankle.
Yeah.
Do his ankles now, so. Keep going. Hey, Gardner? Yeah. Let's come on the other side of Long. Yeah. When we come up, we're going straight up into the chair. All right. Cooper, I'm behind you. And Long, I'm behind you guys. I got you. Yes. All right, I got the chair so it doesn't move. Okay. You two ready? Rolling, go. He's turning. Straight up. Turning. Hear me? Get up.
He's turning blue.
Get up.
Call the squad. Master Control, call the squad.
We need turn him on his side. Turn him on his side. Just laying down on his side.
Leave him on the side. Try to get us some oxygen, make sure everything's going okay for him.
Get him glasses back.
Again, very tough video to watch, but it is the reason that we have that video, that we have this trial of former corrections officer Mark Cooper facing manslaughter and reckless homicide. He was the officer that you could see standing on the back of Rios when they got him down. I'm going to play the video from Friday, new video that we got during testimony. This shows the split second that Rios runs out of that cell, and it is quick.
All right. No. Okay, we're coming to get you.
Ready?
Let's go.
Right there. How many men did it take to take him down?
There's, according to that video, I can see one.
Now we're gonna come get you. All right. No. Okay, we're coming to get you.
Ready?
Let's go.
Right there. How many men did it take to take him down?
There's, according to that video, I can see one.
And that was the prosecution saying if this was somebody that needed to be stood on the back of, how was it that one individual was able to take him down when he rounds that corner. Again, this has been a back and forth trial. Every time the defense, and that's what you expect in a trial, but again, put yourself in the shoes of the jury. This is going to be awfully tough. You're sitting there, you're being told two different things on two different sides, that he was so high on meth that he was able to get out of there in a split second, and that the reason he was had that meth in his system was because he must have ingested a baggie. He had plastic in his gut when the autopsy was done. And that must have been what killed him. But then on the other side, you have on the prosecution, the state side, they say, no, absolutely not. It was he suffocated because he had a man standing on his back right near his neck and his chest, or on the back, on the reverse side of his chest, and that this was asphyxiation, and that he died because of 7 days later. Because of that, basically on life support once he got to the hospital, and never regained consciousness. So a lot at stake for a corrections officer here, facing manslaughter and reckless homicide. Give you a look inside the courtroom. We're still looking at the ceiling, which tells us we are still on our break, but we should be coming back soon. We had a debate between the prosecution and the defense in the questioning of the lead investigator on this from BCI. That second video that we showed you, this video here, he had never seen this video and this version, and that's what's curious, is that according to testimony that we've been hearing, the expert that came in for the prosecution that said that this was a man who died being suffocated. Well, that man was never shown this video, and the BCI investigator, the lead investigator, had never seen that angle of this video. So the defense trying to chip away here. Why didn't you watch that angle of the video? Why didn't you have the plastic bag tested for drugs that was found in his digestive system? Why didn't you review all the video? Why didn't you ask the hospital if they had kept any urine samples from Rios or any other samples while he was in the hospital for those 7 days? You heard the BCI detective say, well, the reason we didn't, I didn't, it was his phrase, it was his investigation. The reason he did not order that baggie to be tested for drugs is that he knew it had been in Rios's digestive system for at least 10 days, and that the amount of acid in his stomach would have eaten away any trace, according to him. It will be interesting when the defense finally takes over on their portion of this case. Remember how I said you can go out there and find an expert that will basically get paid to come in and testify for you, and can basically get them to testify the opposite. It makes me wonder, if you are the defense, is there an expert out there who would have said that testing that piece of plastic absolutely could have found some sort of trace evidence, traces of methamphetamine, if that's what was in the bag, and that it absolutely should have been tested by BCI. Simply having the detective say, well, at one point I had some training, some medical training in college, and I have a basic understanding of biology, and that the acid would have eaten away any evidence of that baggie. That's the reason he is saying he did not get that tested. But you hear it, we're not going to play the surveillance, the camera of Rios on the ground again, but you even hear the corrections officer that's holding the camera. She says something to the fact that he's on something because of his erratic behavior. And I want to play that again. I kind of noticed something watching this second, a third time. Watch Rios bounce off that wall. He hits that wall really, really hard when he comes around the corner. Watch again as he's going to bust out of the holding cell. He's going to make the first turn. It's the second turn that he makes and hits the wall pretty hard. And I just want to watch this again to see if this could have had any impact. Not this wall, right right there. No, he just sort of glances. It's sort of a glancing blow on that wall, and then he is taken down by the corrections officer. Still waiting for the trial to resume here, for testimony to resume. We believe that we will finish up with the BCI investigator, and then the judge will be releasing the jury for lunch. Again, this has been a really discombobulated trial from multiple angles. Granted, this is Richland County. They don't get a lot of cases like this, regardless of whether it's a corrections officer or not. This is a smaller county, probably not a lot of homicides in my guesstimation here. We've been covering this area for quite a while. We get a little camera movement here, which tells me we might be finally closer, and focused on the door here, which tells me we're waiting for the all rise and for the judge to be brought into the courtroom. So we'll stick with this as we are pretty close to getting the trial underway, testimony underway. Again, we will finish the testimony of the lead BCI investigator and then go to lunch, according to what we've been told. We'll wait and see, but I thought that announcement 20 minutes ago was a little bit of an offshoot when we were told at 10:50 that the jury was taking lunch. That's only been hearing testimony for an hour and 50 minutes, and for a trial that's now entering its second week. This trial started last week. The fact that we are still hearing from the prosecution's team, being that this is the lead investigator, I would tend to believe that this may be the prosecution's final witness. So perhaps the defense will start its case when we come back from lunch. Of course, just speculating on that, but we will at least be a little closer. And it looks like we're getting closer at least. So we will wait for the judge. We just saw his court reporter, now going back into where the judge is. So we're a few minutes away, just waiting for the judge to come back in and get the all rise. Been a very complicated case, to say the least. A lot at stake here. Let's also remind you that Corrections Officer Mark Cooper, he stayed on as this investigation was continuing. It took more than a year before he was charged, and once he was charged, that's when he was fired. But he had stayed on as a corrections officer. That again goes back to this idea and a notion that you can put in the jury's head, is that they didn't even know this was meeting the level of needing a grand jury, of having potential charges a year into this. And the fact that the corrections officer was continued his career at the Richland County Sheriff's Department and the jail shows that, at least in their opinion, that this was a routine situation, a detainee that then died 7 days later. Now, had the inmate Alex Rios died that night or maybe the next morning, you can see where there may have been a little bit more urgency, that the magnifying glass would have been used a little quicker. But the fact that he died 7 days later more than likely had a role in the delay in the investigative process. So again, just waiting for the trial to begin here to resume. So we're just going to leave this shot up here as we wait for the judge.
All right. No.
How many men did it take to take him down?
Dan DeRose with Channel 19 here as we wait for the Richland County Corrections Officer for the testimony to continue. Let's keep in mind once the defense is given this case, they will be able to call all of their experts, their witnesses who are going to explain how this should be handled. Let's point that out too. It came out in the testimony of the supervisor there at the jail when they start talking about policy. And they read through the entire policy of what level of force can be used depending on the situation, depending on the inmate. And of course, this was at the top level. This is an inmate who has escaped from their cell, an inmate who was on suicide watch. And here we go, we get our all rise. But it was brought up a couple of times about policy and training, and are they ever trained to stand on the back? And the supervisor said no, but then the defense said, hey, in that whole booklet, nowhere does it say what you are or aren't supposed to do.
Agent Leonard, you indicated with respect to the specimen, urine, or any blood that may be available at the hospital, you testified on redirect that you knew that it would not have been there at the hospital. Do you recall that?
Yes.
Okay. And just so we understand how it is that you reached that conclusion, what you knew was what the retention policy of the hospital was, correct?
That's correct.
And what you knew is that you got the case 10 days in, right?
Correct.
And that was past the hospital policy for retention of urine and blood specimens in a case like Mr. Rios's.
Correct.
Or any case, any hospital stay, right?
Yes.
So you were familiar with the policy for retention and that the time had passed, yes?
Yes.
And from that, you concluded that the specimen wouldn't still be at the hospital.
Right.
To be clear, you didn't confirm that by ever talking to any hospital staff, administration, doctors, nurses, or anyone who could actually check, correct?
True.
Okay. Now, last piece of this, you indicated in some questioning about failure to have this plastic bag-like object analyzed.
Yes.
You indicated that based on your experience as a law enforcement officer, the time that that bag would have spent in Mr. Rios's stomach, your belief is that would make it unlikely that anything left inside the bag would be available for testing due to stomach acids.
True.
You based that on your experience as a law enforcement officer,
Yes.
not as a medical doctor, right?
Right.
And not as a forensic pathologist, right?
Correct.
We've heard the testimony of, I think, 4 medical doctors over the course of a week in this trial.
Yes.
You did not hear any of them make that same statement during their testimony, correct?
Correct.
Okay. And so, in the end, you had possession of this piece of evidence on the chain of custody, came into your possession on September 30th, and you had a degree of control over that piece of evidence from that day until the day you brought it into court here for this trial, correct?
Yes.
You've heard all this testifying about drugs or not drugs and that sort of thing, right?
Yes.
Looking back, wouldn't it have been prudent just to get a confirmatory test done so we wouldn't be having all this conversation?
Objection, argumentative.
And maybe draws a conclusion, so I'll sustain it.
Bottom line is, you simply did not do that in 4+ years on the case, correct?
That piece was not tested.
Nothing else.
Okay, do any of the jurors have a question for Special Agent Eric Langhart? Okay.
So this has been an interesting part of this trial as well, something I've never really seen before. I'm not saying it's doesn't happen, but I just haven't seen it very often. Whenever in this judge's courtroom a witness gets done testifying, the judge then turns to the jury and to see if they have any questions of that witness. And you just saw the bailiff for the judge walk over to the jury. The question has to be written out. Then that question goes to the judge, and he has a sidebar with the two attorneys because they have to look at the question itself and debate whether that is a legitimate or a legal question that can be asked. You can't just, you might say, well, boy, shouldn't you just ask, if you're on this jury, shouldn't you ask the question if this lead investigator thinks he did it? Well, you can't ask that question. That's hearsay, that's speculative. His answer would be speculative at best. And so you can't just ask anything. But it has been interesting in the past couple of witnesses to see the questions that do or don't get answered by what's the consensus of whether or not the question can even be answered. You heard the defense there at the end again, and I've been pointing this out all morning. You are the lead investigator on this from BCI. You had that plastic bag for 4 years, the bag that was taken out of the digestive system. Let's see what we get for an answer. And you never had it tested. And that was the point he was trying to make for the jury.
Arrested and brought to the Richland County Jail. You indicated that you didn't see any video of him going through a scanner, but you did see in the booking process that there were some check boxes. So the question I think relates to that is, was there any notation when you saw those check boxes of his behavior when he was being booked into the jail, not when he was in the booking room, what we've seen, but prior to being put into the pod, the general population pod? Was there anything that you noted that you recall about his behavior or attitude at that point, impairment, anything of those?
The paperwork indicated that was done by the COs that booked him in. There was no indication on those documents of they're recognizing him as being impaired or being agitated or anything like that. So it was, the paperwork was pretty unremarkable, and when I say that, I guess I mean that it wouldn't have been any different than any other person coming into the jail. There wasn't anything specifically on that paperwork that was marked to recognize the fact that he had been an issue at that time.
Does that bring up any additional questions from the prosecution?
No, Your Honor.
From the defense?
No, Judge, thank you.
All right, thank you, Special Agent Langhart. You can step down. Appreciate it. Does the prosecution have any additional witnesses that they want to call?
No, Your Honor.
All right, so ladies and gentlemen, what's going to happen is the state's going to rest at this time, which means the prosecution at this point has called witnesses they want to call, what we call in their case in chief. So what I have to do now is I have to do part of my job as judge of the law that you don't need to be involved as part of the judge of the facts, which is we're going to go over exhibits and talk about exhibits outside of your presence. So I think it makes sense, we're a little bit early, but I think it makes sense to let you have a lunch break. And so then have you come back. Now when you come back, it's the defense turn to decide if they want to call witnesses. They don't have a burden of proof, they don't have to call witnesses if they don't want to. They may want to call witnesses. There's also some conversations that I need to have with the parties about jury instructions and things like that. So why don't we have you come back in an hour and 10 minutes from your lunch break, and at that point we'll see where we're at as far as if any witnesses are going to be called by the defense at that point or not, and go from there. But we are making progress, so we are getting towards the latter end of the case, I suspect. So we'll see everybody after your lunch break. Same instructions. I always tell you, if you've heard them now probably 10 times, same instructions about not talking to anybody, not having any opinions, no media coverage, paying attention, and no research or investigation. See you back here in about an hour and 10 minutes, and we'll continue on. Thank you.
Dan DeRosa with 19 News. Now we're going to stick here for a couple of minutes. I know the jury is being sent to lunch, but you heard the judge say that he has to take care of some issues with both parties before the defense can start calling witnesses. Now, one of the things that is generally done at the end of the prosecution, when they're done and they say, we rest, we have no more witnesses that we're going to call, normally the defense will make a motion. And that motion will be to the judge, something to the effect of, Judge, we don't feel that the prosecution has made their case beyond a reasonable doubt. We don't think that they have proven anything to the jury. And this happens really across the board in all trials. At that point, the judge has to decide, well, is the defense right? Did the state not prove anything? And the judge could throw out the entire trial right there and say this is over. And it does look like we're going to go back on the record that it's really a last-ditch effort. And it does not work 99.999% of the time. But as a defense attorney, you have to try it. You have to throw it in there. So let's listen in on the court.
Is that being offered?
Yes, Your Honor.
Yes, Your Honor.
Subject to the admission of the exhibits, we would rest, but yes, State's Exhibit number 1, titled Kent Harshbarger, coroner, Montgomery County, postmortem examination.
Okay. Any objection to the autopsy report?
No objection.
It's in. I have State's Exhibit number 2 being the death certificate. Is the state offering that?
Yes, Your Honor.
Is there any objection to that?
There's a couple of them. This is the death certificate that indicates the manner of death. Accident.
Cause and manner.
Cause and manner of accident, yeah.
It's the supplement. Yeah, no objection.
Okay. 3 is the, looks like video of the incident in the jail. That's the handheld. Any objection?
Well, it's both, Judge. It's the handheld and the compilation. They're both contained within State's Exhibit number 3, and we've played that. It's been identified by several witnesses, and the compilation was identified by Agent Lanehart.
Any objection?
No, sir.
That's in. State's Exhibit number 4 and number 5 are photographs of Alex Rios. One is a photograph of him, and one of them is photographs with his kids that were offered, I think, when his mother testified.
Yes.
Being offered?
Yes.
Any objection?
No.
Okay. 6 is the item taken from his stomach during the autopsy being offered.
Yes.
Any objection?
Nope.
All right, that's in. 7 would be Dr. Mitchell's report, expert report being offered.
Yes.
No objection, with the exception of we think it's appropriate to redact the portion of the 2 lines with respect to the Davison report and the phone summary of the interview with scientist Davidson. Their bullet points, maybe 3 and 4, that are the subject of the discussion we've had in this case. I don't think there's an issue with that.
And I think we agreed that those would be taken out. So, yeah, I'll allow that in with the idea that where it says Bureau of Criminal Investigations, BCI report, polyvinyl chloride material, we black that out. And then the next blackout would be notes taken by Special Agent Eric Lanehart during the Friday, June 12, 2020 cellular phone discussions on scientist Davison's findings. I think that we agreed that that would also be blacked out, but otherwise I think everything is okay on that report.
So, Judge, I don't have a black marker. Does anyone? I still don't have it right now, so there's not a mistake.
Okay.
there's bleed through, we could even make a copy of it.
Yeah, I think we just want to have like a block put over it. I mean, they can still like look at it and then make a their sticker on it, and that'll be our cover page, but we'll get there.
Okay.
You know, as long as it's complete, I just don't want the jury trying to look at the portion reports and things like that.
Is there any motion,
Are those all the exhibits?
I think those are all that are being
That's it.
voted.
I'm sorry.
That's the rest.
All right, any motions being made by the defense?
Yeah, at this point, we will make a motion for acquittal pursuant to Criminal Rule 29. Of course, we're aware of the standard at this point, we're going to fish the case, evidence like this, we're going to stay, even still. We are asking the court to dismiss this case, given the evidence that we've heard, specific attention to the competing expert views in this case as the cause of death, and the quality of that testimony as it relates to reasonableness of force and also approximate cause. We think that there are legitimate issues there as well for this stage of the proceeding, let alone as relates to later being a jury question. Specifically, the state has offered testimony from their expert indicating that the suspect approximate cause of the death, the theory being the felonious assault and or assault committed by the 7 seconds that our client is on the back or neck area, depending on the testimony that we've heard viewing the video. With respect to this case, we've heard extensive testimony regarding reasonableness of force. While we're still arguing over the appropriateness of how that will be discussed in jury instructions, we believe it is right smack dab in the middle of this case and it's relevant for the discussion that we have right now. Specifically, there was discussion on the first break this morning about use of force and reasonableness in the context of the Ohio Administrative Code. Mr. Thompson did correctly point out that the code section that we were initially bringing to the court's attention speaks as to corrections officers in the prison setting. We continue to look at the Ohio Administrative Code during the 10 minutes that you gave us before getting back on with Officer Lainert or Agent Lainert. And specifically, we can direct the court to the jail section and the sheriff section of the Ohio Administrative Code that specifically grants the ability to use reasonable force in the reasonable taking control of an inmate that is otherwise non-compliant or resistant. We would direct the court to ORC 341.01, indicating sheriff shall govern and regulate according to minimum standards for jails promulgated by the ODRC. The argument has been made that policies cannot supersede or otherwise trump the ORC. Well, this is directly contained within the ORC, and this is law, and it specifically lays out in OAC 5120:1 through 8 full-service jails, and talks about use of force and the essential standards, and we would direct the court's attention to that. Compare and contrast those with the testimony that was offered, and specifically the use of force continuum, which was identified as the policy in place for use of force at the time. What the court will find is it's a virtual cut and paste job from the Ohio Administrative Code section governing how the sheriff shall implement use of force policies as reasonably laid out in the Ohio Revised Code as the law. And those provisions, as I indicated, are what are laid out in the policy that is at issue in this case. And we feel it's clear this was an effort to bring a, not arguably, but obviously non-compliant inmate into compliance for his own safety and that of everyone else in the jail, including that of the guards, and that the restraint is not over until the inmate, per policy, is in fact cut. And in this case, that did not happen to the very end, and certainly did not happen prior to our client using the force that has been deemed as the force alleged to have caused the death. We believe every measure taken by our client in this case was reasonable, and looking only at the tragic result ignores what was happening before and during the time the force was used. When I talk about that, I speak specifically as to the actions of Mr. Rios. We do not believe that any reasonable jury would think otherwise, and we ask the court to conclude as such and grant Rule 29.
That code section, before I hear from prosecution's response, ORC 341.09.
01, I believe, Judge.
34101. Is that the one?
Yes, and that speaks about the sheriff governing and regulating according to the standards for jails promulgated by the ODRC. So it essentially transitions that. Essentially accounts for exactly what Mr. Thompson was arguing on us about 15 minutes ago and directs us to the jail section. And when we do that under OAC 5120, 1 through 8, what we're going to see is a cut and paste job essentially by the Richland County Jail to be in compliance with Ohio law when it comes to use of force policy. And so once again, getting a little far afield here, assuming that this trial does continue on, notwithstanding the court's current ruling, we believe it's appropriate to revisit just the standalone jury instruction as proposed or altered to clearly take into consideration the Ohio revised language. Thank you.
From the state.
Yes, Judge, thank you. And looking at the evidence in the light most favorable to the state of Ohio, which is the standard, as this court is well aware, the state believes that a reasonable jury could find that Mr. Cooper is guilty of all 3 of the charges. We've presented evidence of each and every element of each and every offense. We presented evidence of cause of death and manner of death. We certainly believe the standard is knowingly cause or attempt to cause, knowingly cause serious physical harm. Clearly the death is serious physical harm. I think it's clear that Mr. Cooper acted knowingly. Mr. Cooper acted knowingly in causing physical harm, necessarily as a lesser included offense. And certainly a jury could believe, if they don't believe he acted knowingly, that his actions were reckless with heedless indifference to known consequences or risks, being that when you weigh 250 pounds and you stand on a prone person's back with their arms and legs behind them, that you could cause serious physical harm and or death, thereby resulting in death. So, Judge, we believe that, again, a reasonable jury could find, don't have to find, but that's not the standard, could find, if believed, if all the evidence is believed that the state has offered, they could find him guilty of all the offenses charged, and we ask that the motion be denied at this time.
Thank you, Assistant Prosecutor Salisbury. I do think that in the light most favorable to the state, which is how the court must look at it, I think there is a reasonable jury could conclude in the light most favorable that the defendant did violate the sections that he's been charged with, so all of Rule 29. As to the issues, I did have a chance in the break I looked at a State v. White, 142 Ohio State 3rd, 277, State v. Bolton, 2018 Ohio 1551, another State v. White, 2013 Ohio 51, and just really glancing at those briefly, I think they do talk about a situation where a law enforcement officer on duty used force and ultimately got charged, and so there's discussions as to justification and those kind of things. So I do want to look at those. I also would want to look at the new code section that's been provided, the administrative code section that's been provided, and look at a possible instruction either as to reasonable force related to corrections officers or to this affirmative defense of justification as related to a corrections officer. Truthfulness, at least, I will say, at least these cases, at least the first one I looked at, looked like it was directly talking about a situation that's similar to what we have here, which is an officer on duty trying to arrest somebody or at least detain somebody, and then ultimately that individual was shot. It's different because it was gun use, but the discussion is similar, such that at least it gives me somewhere to start.
If I may, Your Honor.
Yeah,
If you're referring to the State v. White, the original case that was cited,
yeah. Well,
that was to a law enforcement officer. Corrections officers are not law enforcement officers. I'd ask the court to make that a distinction, in its analysis.
And the other two, when I jeopardized the first State v. White, the other one two popped up. So
I believe, I haven't looked at the Bolton case, but I believe all of those cases refer to law enforcement officers.
Okay. I understand. So I guess what we'll do is we'll take our lunch break and we'll come back and go from there. Okay.
That's fine, Judge. We don't require a record for the next portion of the meeting, but I would like to talk about scheduling.
Okay, all right. So we can go off the record. Schedule it?
We requested that stream as well. For the
Okay,
record.
since we're off the record, we can just go ahead and go off.
As you heard there, the defense attorney is asking for an off-the-record discussion with the judge, to which the judge then just looked at our camera and said that this needs to cut off the stream. That is understandable. If it's not on the record, and if it's not being taken into the record by the court reporter, then we turn our cameras off. That goes without saying. So let me explain what you just saw there. You saw the defense ask the judge to dismiss this case, that they didn't meet the burden of proof, that a reasonable jury would never find his client guilty based on an Ohio Revised Code of getting an inmate who has escaped, getting them in custody by any force necessary until the cuffs are on. They argued that the use of force was all before the cuffs were put on Alex Rios on the floor. You then heard the state say, no, that doesn't apply here. And even the cases the judge was citing, that those were police officers that were using deadly force in a situation. You have to remember, corrections officers are not sworn officers. They didn't go to police academy, and so they are not subject to the same sort of rules that apply for police officers. The judge is going to take it under consideration. Look, we see this in every case. When we get to this midway point, when the state wraps up their case, you get the defense that starts before they start their case. They start with a request for the judge to dismiss the entire thing. Again, 99.999% of the time, the judge never dismisses the case. They let it play out and they let the jury make the ultimate decision. They're going to take their lunch now. I believe they will probably come back on the record around 12:30, maybe a little bit later, to discuss a couple of things before the jury comes back in the room, to be able to discuss what the defense plan is, who their experts are, and where they're going to take their testimony in the next couple of days. So it took exactly a week for the prosecution, for the state to lay out its case. We are not sure how long it will take the defense. It all comes down to how many witnesses they want to call. So we too are going to put up our standby slate and wait for the court to go back on the record. Again, that's expected to be around 12:30, so we will pick up our stream about then. Until then, I'm Dan DeRose with 19 News. We'll see you around 12:30.
So 2, channel 2, and channel 1, 1. All right, I'm gonna shut it down, shut down the audio and go to the ceiling until the judge is ready.
officer is not just appropriate in criminal prosecution, but it is necessary in criminal prosecution.
Good afternoon. I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We continue our gavel-to-gavel coverage, just resumed in the case against the former Richland County Corrections Officer Mark Cooper. He was seen in a video where they were detaining an inmate who had just broken out of a jail cell. He was seen in the video standing on the back of Alex Rios. Rios would go unconscious there in the jail, transported to a hospital where he would die 7 days later. The judge is back on the bench. This could be procedural. We'll see if the jury is back in the room. The defense is about ready to start their case, which means the judge needs to make a ruling. First of all, the defense asked for the judge to throw out the whole case. That's something that's done at the halfway point of just about every trial. The judge is giving his reason now why, whether he is or is not throwing out the case. Let's listen in.
Necessarily in the, I don't know that the court gave the instructions because it was an affirmative defense, or gave the instruction and then the defendant argued for an affirmative defense. But I do think that, I think that if I don't say anything about reasonable force related to this situation, I think that the problem is the case law that I've been looking at says I have to. Now, do I do it as an affirmative defense? Do I do it just as a blurb like this, the defense wants me to give? I don't know. But that's where I'm at. I'm not prepared to tell you what that instruction is going to be right now, because literally I had about 30 minutes to look at all this. But that's where I'm at. So I think the most prudent thing would be to send the jurors home and do this at come in, maybe we meet early in the morning, we talk about it, and I tell you my decision, and then you can argue about it. Likely at that time, my decision will be my decision. And we can argue about it, but probably will be whatever it is at that time.
Judge, if we'd like to make a filing, even perhaps before the end of the day, to serve on the other side, and
yeah, both sides
or first thing tomorrow morning.
Yeah, both sides want to help me out. And I don't know what the state's thought process is. It just looks like if you don't put anything in there at all, it looks like the one case says you must. Now, it's talking about law enforcement, but it's talking about use of force in a situation where someone has the authority to use it. And that's what we're talking about in this case. COs and police officers have the authority to use a certain amount of force. What they don't have is the authority to go beyond that reasonable force. And then the issue in this case becomes, we know Alex Rios died, but it's not like a situation in these cases where the officer pulled his gun and shot the person. That's clearly deadly force. In this case, argument of standing on someone's back for that period of time, is that deadly force? Some say yes, some say no. So that's another issue that's convoluted. So thoughts from state or defense on that? My thought is I send them home and try to fashion something and go from there.
Well, Judge, if you intend to have your mind made up when we get here tomorrow morning, we're going to do the best we can in the 3.5 hours that we have before the clerk's office closes to get something filed. And we, of course, will serve it on Mr. Thompson and Mr. Salisbury. We also would reserve the right, I guess, to email something this evening if we can't get there. And I would text Mr. Thompson to let him know that we did, vice versa. I assume it would be reasonable. And we also would email it, I guess, maybe, or fax it to the court. I don't know the best way to get it to the court.
It might be helpful to come back.
The court's closed at 4.
Yeah, it might be helpful to come back at 3:45, both sides and tell me what we have, because again, what I'm afraid of, and what I know probably is going to happen is we get back here at 8:30.
Right.
I have something in mind. Probably both sides won't like it. Will be probably where we're at, and that's typical. And then we're going to be trying to rehash and change it up and do stuff. So I'd rather have something in mind from both sides. Even if you hate it,
Which is
I'd rather have it, you understand.
We'd at least like to be on the record as to where we think it is, and I think we can be in that position by 3:45 this afternoon, or at least something we could file.
You know,
We understand that.
for us, it's logistics.
Right.
And we're an hour away.
Yeah,
So we lose an hour before we get started.
it's true.
So
What about,
if we're able to email it,
yeah,
and email it directly.
Could we do it, by a call? Could we do it?
say, because it's gonna be different, they're gonna be driving for an hour before.
Yeah.
The idea, I think their issue, not to speak for them, but I think they're getting to 3:45 is what's problematic. And it sounds like they're saying, if we could get you something today that you could have to be working with this evening, I think it's reasonable we can get something, both sides can get something this evening. It's just a matter of how do we get it to you, given the fact that the court will be closed. Is that fair, of
Yeah.
course?
Yes.
Yeah, and I'm good with that, however we want to do that, whether you email it to us, fax it to us, whatever. You know, and you know the stuff I'm looking at, I put on the record the cases I'm looking at. That's where I'm gonna start and try to figure it out.
Does that, Judge, if I could ask, does that include a definition of what is reasonable force? Or it just says reasonable force?
Well, when you look at the case law and it talks about, I'm looking at the Ohio Supreme Court, and even just to put this on the record so everybody understands where we're at. This case by the Ohio Supreme Court from 2015 was far from unanimous. It basically had concurring opinions, dissenting opinions, you know, people concurred in part and dissented in part, so it was all over the map. So we're at a point where this is very difficult for any of us to wrap our heads around what this is, because even the Ohio Supreme Court in 2015, those justices were all over the place trying to figure out where exactly this should come down. And so it's that kind of an issue, but it said that one of them says Ohio courts recognize that a police officer is justified at common law to use reasonable force in the course and scope of his law enforcement duties. And then it cites the second district case that talked about that case involving the prosecution conviction of 2 police officers for assault and battery. A peace officer duly employed is not liable for injuries inflicted by him in the use of reasonable necessary force to preserve peace, to maintain order, to overcome the resistance to his authority. Thus, an officer making an arrest is justified in using sufficient force to subdue a prisoner, although not acting in self-defense. However, if unnecessary violence is used by the officer in accompanying his purpose, or if he assaults the person with whom he is arresting without just cause or excuse, especially after resistance to his authority ceases, then he loses these protections under the law. So it goes all the way back to a common law idea that you have these rights to do your job, but you can't go beyond those. So I mean, I think that the idea would be explaining to the jury that, and trying to do this in a way that fits this case, but that as a corrections officer, he does have the reasonable use of force, but he can't go beyond that. He can't go beyond it. So it's going to be me trying to fashion something like that from the case law, and I'll look at the Ohio Administrative Code and try to come up with something. And of course, it says the other thing I read in these cases: if you don't say enough, that's a problem. But if you say too much, it's a problem too. So it has to be just right. Well, that's this.
You're just a man for the job, Judge.
Yeah. No, all right.
We'll see what we can do to help you out.
All right. All right. We'll bring the jurors in. We'll explain to them what's going on. We'll bring it back at 9 o'clock, and by that time we should be ready to proceed.
Yeah, this part.
Dan DeRosa with 19 News. What you've been watching is a very interesting development in this case. As I said, when the state rested its case, it's very common that the defense then, before they even present their first witness, they file a motion asking the judge to throw out the case. This happens in all kinds of cases, almost every time. And 99.9% of the time, the judge doesn't agree and the case continues and the defense calls their first witness. Well, we've got to hit the brakes here. The judge, after the defense cited 2 appropriate cases, looking at the use of force when you are a police officer. The problem with that is corrections officers are not sworn peace officers. It is a whole nother breed. But the judge is saying he now needs to look at these cases, and in particular, a ruling by the Ohio Supreme Court in 2015, where it does talk about justifiable means to subdue a prisoner, and that what is determined as an appropriate use of force, because in common law or case law, a corrections officer / police officer is allowed to use some semblance of force. The judge is asking for the defense to prepare something in writing, to which it looks like he's going to dismiss the jury right now, send them home, so that the defense can get something written up and submitted by this afternoon, so that the judge can have it tonight to make a ruling tomorrow morning. Yet another twist and turn in this complicated case.
Gentlemen, when you were gone, we did have an opportunity to do some things. Part of my job is not part of your job, discussing exhibits and those kind of things. Like I told you, the state is rested. They've admitted all the exhibits. All the witnesses. They've had all the witnesses testify that they want to have testified. It's now the defense's turn. As we talked about, the defense doesn't have to call witnesses, but they can if they want to. I think at this point, it would be more prudent for me to let you go home and come back at 9 o'clock in the morning. We're getting close to being at that point where we're going to get the case to you for your deliberations. I suspect that will happen tomorrow. There are some issues that myself and the parties need to come up with, and these, they're not simple, let's put it that way. So in the effort of trying to resolve things so that they're done properly on this side, so that you can render your verdict properly, it's going to take some work from the parties and myself. And it's not something that I want to make you sit around and wait. And it's not something I certainly want to rush. I want to make sure it's done right. And so I think it's better that we take our time and get it right so that you can deliberate fairly and accurately. So what we're going to do is let you go home, come back at 9 o'clock in the morning. By that time, we'll have an idea of where we need to be. At that time, we'll see if the defense has witnesses or not. If the defense does not have any witnesses, we're ready for jury instructions and closing arguments. If the defense has witnesses, then we'll hear from those witnesses. And unless the state would have rebuttal witnesses, then we'd be ready for jury instructions and closing arguments. And we have, so you know we have been working. I do have proposed jury instructions already done. The parties are looking at those to go over. We have proposed verdict forms already done. The parties are looking at that. But there are some things that may need to be added to this that's what we need to discuss. So that's why I think it's better not to try to have you wait around to see if we can get this done while you're waiting. I think it's easier to let you go home, come back. But it looks like we are on course to get this case to you tomorrow. Remember what I've always said about these cases. Whatever decision, whatever verdict you come up with in this case is the right decision, whatever that is. You're to disregard. If you think I have an opinion, I want you to disregard it. It's not. It's your job to decide facts, not mine. There's no time frame and no right or wrong answer. Whatever you decide is the right decision, and there is no time frame that if you can decide it quick, long, whatever it is. Your main effort must be to arrive at a just verdict based on the evidence and the law and the facts that you determine have been established in the case. So we'll see you back here. Same instructions. Don't discuss the case. Don't form or express any opinions. We're getting close. We're getting close to that point where we want you all expressing opinions, but that's not until deliberation. Come back tomorrow at 9. Don't pay attention to media coverage. Don't do your own research or investigation. See you back at 9 o'clock, and we'll continue on. Thank you.
So that is, in fact, what's happening. They are going to wrap up for the day in this trial because there's a lot of work that needs to be done behind the scenes, especially on the part of the defense attorney. He filed this motion asking for the trial to be thrown out on this idea that as a corrections officer, he is allowed to use some level of force. Is that standing on the back of an inmate who's pinned to the ground? The problem is, there is no case law that says what is and isn't justifiable force in a situation where an inmate has escaped. Of course, there is nothing that says you are allowed to kill an inmate unless that inmate is using deadly force or has gotten a hold of a weapon themselves. So this is going to be tough for the judge. And we heard a little bit of an indication, and I'm staying on this because I want to see what the judge ultimately ends up telling the attorneys as far as a time frame here. And it looks like we are back on the record.
If it ends up being 5 or 6 or something in the evening, is there a mechanism by which it could get to you, Judge?
Probably not like an email or fax. Probably not. If it's so, probably not that late. Probably not.
We'll do the best we can.
And is there an idea of meeting early in the morning? Do you want to get here earlier than normal? Is that helpful? Let's see if I have anything else on my calendar before it's 9 o'clock.
So Judge, just speaking from the top of my head, what you read from that case seems to be appropriate to that language that you read. However, the only thing that I would say that I would maybe suggest to the court is the precursor of if you find that force was necessary, then it had to be reasonable. I mean, I don't want it to be a foregone conclusion that the force was necessary. You know what I mean? Like, if you find that the officers needed to use force in this case, it had to be reasonable force. So that's the only kind of precursor I would add.
If I don't have anything until 9, 8:30.
It's fine. If it's okay.
Fine.
It's fine.
Let's reconvene at 8:30, and I'll show you what I have at that point. And I'm going to try to keep it succinct, but we'll see how much is in there. And then it's probably going to have everything we've talked about. You know, what Attorney Mayor provided is, I'm reading quite a bit of this out of these cases. The only difference is we're applying it to corrections officers as opposed to law enforcement officers, because these cases are an officer making an arrest where there's resistance and how much force can the officer use to affect the arrest. This is somewhere in that vein, but not quite the same thing. So, all right, thanks everybody.
If we have things to get to your attention.
Dan DeRose with 19, just going to keep an eye on that to make sure they don't go back on the record here. But you're seeing kind of a bombshell moment play out. Normally when a defense attorney asks a judge to throw the case out before they start their defense, basically saying the prosecution, the state, they didn't meet their burden of proof. They didn't prove that a corrections officer is not allowed to use reasonable force in the case of an escaped inmate. And that's what we have here. We had an inmate that they were going to try and shackle while he was in his cell. They do that by opening the food flap. We've all seen enough movies. They open up the food flap, you stick your hands through, they get the cuffs on you. Alex Rios was not going to do that. He was not complying, so they opened up the cell door to go in and detain him, restrain him. They said for his own safety that he was acting erratically. And as they did that, he took off running. And so the question is, as a corrections officer, what amount of reasonable force is he allowed to use? He is protected by the law in some fashion. You have an inmate that escaped their cell. So the question is now for the judge to decide. It did sort of sound, I mean, normally the judge can weigh this and then say, but ultimately let's make the jury decide. And I think he was leaning that direction. And even when the jury came back in the room, he has to be careful what he says. He can't tell the jury that this is what he's thinking about and this is where we're at. Because if you tell the jury, I have to go home tonight as the judge in this case and decide whether the whole thing should be thrown out, and then you come back to court tomorrow and say, oh, well, we're going to continue with the trial, that shows that the judge is leaning that no, that's not an acceptable argument, and you would influence the jury. You would bias them with the judge's opinion. So that's why he was not allowed to explain to the jury why they are being sent home at 1 o'clock in the afternoon. And this will resume. There was talk, you may have heard, of can they get this done by 3:45? Can we get back on the record so that we can start again at 9 in the morning? And then you heard the judge say that the judge told the jury, hey, we're very close to getting you this case. It may even be given to you tomorrow. You heard the judge say the defense may or may not call witnesses, their own witnesses. So it'll be interesting, but the judge said we're close. He even thinks that they're going to give the case to the jury tomorrow. That tells me that the defense does not have a lengthy list of witnesses, may not have a list at all of who they're going to call tomorrow, but if they do, it would be a short list. So yet another twist and turn in this very, very complicated case against former Richland County Sheriff's Department Corrections Officer Mark Cooper. And so we will pick up again. It sounded like the judge will have the attorneys come in at 8:30. Whether we go on the record at 8:30, we will be ready to continue our gavel-to-gavel coverage. They may reconvene at 8:30. The judge may give his opinion on the request for dismissal. And if the trial continues, which the judge kind of made it sound like it would have to be a very convincing argument, and he cited the 2015 Ohio Supreme Court case and said, look, even those Supreme Court justices were back and forth, some agreeing, some dissenting opinions on what is an appropriate use of force. And then you heard the prosecutor right there at the end asking the judge, sort of giving his last chance, last-ditch effort before the judge went home for the day, saying, if, Judge, I just want you to consider, if force is necessary, it has to be reasonable. And where the judge falls on that is really the crux of what will happen if this case moves forward or not. We will commit, we have committed to gavel coverage. We will be back with you probably right around 8:30 tomorrow morning as the judge gives his opinion on whether or not to throw out this case. Until then, I'm Dan DeRose with 19 News. Have a great afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland 19 News.